Before we begin the arguments for this morning, I'd like to inform the members of the bar of a very unique initiative of the Supreme Court. We have prepared a handbook. Before we begin the arguments for this morning, I'd like to inform the members of the bar, judges, and the legal community in identifying, understanding, and combating stereotypes. We have prepared a handbook legal discourse on combating gender stereotypes. It contains a glossary of gender unjust judges and the legal community. Alternative words or phrases which may be used while drafting stereotypes as well as orders legal discourse. So it reaches out. It contains a glossary of gender unjust terms, and the handbook identifies common stereotypes about women, drafting pleadings, many of which have been utilized by courts in the past, and demonstrates why they are inaccurate and how they may distort the application of the handbook identifies common stereotypes about women, or cast doubt on many of which have been utilized by courts in the past, may unwittingly be why they are inaccurate to raise awareness against the utilization of harmful stereotypes, particularly those prejudicial to women and past judgments. The handbook aims to explain what stereotypes are, and helps to raise awareness against the utilization of harmful stereotypes, identifying language to women that promotes gender stereotypes, to explain what stereotypes offering are, alternative words judges identify and avoid such stereotypes, identifying common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect. Alternative words and highlighting binding decisions of the Supreme Court of India that common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect. It's been you have the first page of the document here on the stereotypes, and it's uploaded. It will be uploaded very shortly in a minute or two on the website. It's been you have the first page of the document here on the screen, uploaded on the website right now. It's uploaded. It will be uploaded very shortly in a minute or two on the website of the Supreme Court of India. In a couple of days, we'll be also uploading a simple video on the website right now on how to do e-filing for members of the bar who just require a little bit of hand-holding on that. In a couple of days, we'll be also uploading on the website simple video tutorials on how to do filing for members of the bar who just require a little bit of hand-holding on that. So that's all. It should be here on the website in a minute now. Thank you, Dr. Krishna. Or a few minutes. Yes. Thank you, Dr. Krishna. Yes. No, but Mr. Dwivedi, if you start using it, you'll find it so simple actually. No, but Mr. Dwivedi, if you start using it, you'll find it so simple actually. Please do answer them in your submissions. No difficulty. Addition, you know. We are making notes, so you can always make the addition in your answer them in your submissions. No difficulty. Mr. Sorry. Mr. Dwivedi, I'll give you a concrete example. We are making notes, so you can always make the addition in your own. Now it's almost done. On Hindu law, so whether Mr. Dwivedi, I'll give you a voidable marriage is entitled to a share in formulating a judgment. We are still now. So today, over the last few days, I've opened the file on Hindu law as to whether we don't have any such limit as we have now imposed here. Is entitled to a share. 3 or 4 written submissions by each member of the bar. Over the last few days, I've opened the file. Each member of the bar. We didn't have any such limit as we have now imposed judgment because you have 3 or 4 judgments of different genres in different submissions coming up compilations by each member of the bar. It becomes impossible for the judges to dictate a judgment because first today in the morning I was telling my secretary, I said, we first need to now submissions all the judgments, prepare a separate file, put them in chronological order. But even then it doesn't help because you have marked what was being read out by the lawyer. I said, we first need to now look at all the judgments, prepare a separate file, put them in chronological order. But even then, it doesn't help because you have marked what was being read out by the lawyer. As it is available today. So, this is the real problem. The concept of doing written synopsis was comparatively not there. Everything used to be argued. We used to take down notes and dictate. Now, the purpose of a submission or a synopsis, as I understand, was comparatively facilitating dictating. Not there. Everything used to be argued. Instead of that, it becomes so much more cumbersome. Now, the purpose of a submission or a synopsis, as I understand, thousands of pages used to not be facilitating dictating the judgment. So that's instead of that, it becomes so much more cumbersome that we have many cases of this category where these kind of pleadings of thousands of pages used to not be filed. Thinking they are certain. So that's
Dwivedi, my take on this has been There are many cases of this category.
In the office is thoroughly done.
No.
Normally this problem doesn't.
Let me thinking they are certain.
It is possible. Take on this has been.
The judgment can never be complete.
The homework in the office is thoroughly
The judgment can never be
Normally
complete. That thought process will continue from your side.
You know that
It continue from our side.
possible.
My fear always is the
judgment
judges
can
that
never
in
be
this
complete.
process I've missed out some very important
The judgment can never
point
be
of judgment
complete.
because it's
That
all
thought process will
sort of
continue from
placed
your
in
side.
different
It will
silos.
continue from our
That's
side.
what is really worrying for us as judges that in this process
trying
and collating can always do that point tell our law clerks to put all the judgments together in a chronological order. That's what is really worrying for us as judges. This just about reading, trying and collating can always do that. Over tell our law clerks to put all the judgments together in a chronological order. Danger is you feel that, oh my God, I might have just missed something because things come in, driblets 30 minutes time and 1 hour's time. So we need to now just.
The US Supreme Court do it in 30 minutes. The most complicated case, they only hear you for 30 minutes.
Supreme Court gives 30 minutes time and 1 hour's time.
Including
so
time
to now just.
The US Supreme Court do it in 30 minutes. The most complicated case, they only hear you for 30 minutes.
No, we are far more advanced technologically.
Including time.
Actually, trust me,
of the court.
we are almost at the high end of the curve in India. No, we are far more advanced technologically. Actually, trust me, we are almost at the high end of the curve in India. Yes. So that we can just keep it on the dais, as the hearing. That would be very useful. Yes, that you want to refer to. Yes. And again, so we can just keep it on the dais. That's very useful. Or you have also put it in a plastic. You want to refer to. And again, referred to. That's very useful. Or you have also put it in a plastic. Oh, excellent. Yes, Dr. Lama.
No library talk this time, my lord.
Oh, excellent.
But start again, my lord. I appear for the JK People's Conference,
Yes,
my
Dr.
lord.
Lama.
No library in writ petition 1165. But start again, my lord. I appear for the JK People's question that your lordship put to Mr. Sibal was in writ petition 1165. Presidential proclamation of 19th December. We've challenged the suspension, and that is very important to our argument on Article presidential. There is also another petition, December. We've challenged the suspension, and that is very important to our argument of 2019, which actually there is also another petition, my lord. Sohail Qureshi 1068 of 2019, which actually challenges the proclamation.
2068, right?
1068.
Yes.
Now, Lords, I would begin by saying, as well from my Lord the Chief Justice, that this oral submission is in the nature of a dialogue. And a very important dialogue would begin by saying, the US Supreme Court as well from my Lord the Chief Justice, everything is read. This oral submission is in the nature of a dialogue. And it is because of the nature of the dialogue, which even on an ongoing basis answer everything what fell from your lordship. There's a bit of question and answer. I'll give your lordships an example. And it is because of the nature of the dialogue, we have to, on an ongoing basis, answer reference what fell from your lordships as well. I'll give your lordships an example. 249 and 252. Chief Justice made a reference. Of course, they are of a different genre. But nevertheless, 249 and 252. Of course, they are of a different genre. But nevertheless, my lord, very, very important. Question is very, very important. To build the diversity argument. And whether there is diversity argument, constitutionalism, and whether there is transformative constitutionalism, basic structure, whether that's a lost cause or not. Then, my lord, your lordships had asked questions about Article 3. Then, my lord, your lordships had asked questions about Article 3. And whether Article 370 subclause 3 survives. Article 370 now, this is important because it's been used only twice. Now, this is important because it's been used in Geo 44, my lord. It was used and now it has been used once again. In Geo now it has been used once again. In Geo if it doesn't survive, my lord, how can it be used if it doesn't survive, my lord? We have to answer that question in this particular way. We have to in addition to that, my lord, In addition to that, there was confusion or misunderstanding on the status of misunderstanding on the status of merger from your lordships was the question that once the instrument of accession is over, that once the sovereignty of accession is over, sovereignty is complete. Submission, my lord, on this which I will elaborate. I've done it in a note on this which I will elaborate. Like Mr. Zafar, I've done it in a note, my lord, to your lord. Like Mr. Zafar, I'll hand over that note, my lord, to your lord. 3-7. Lord, as far as the instrument of accession is concerned, as far as the instrument of accession is concerned, sovereignty. It deals with external sovereignty. It's very important. External sovereignty is lost. External sovereignty is lost. With a few exceptions here and there. With a few exceptions here and there. But internal sovereignty is not lost. But internal sovereignty is not lost. They say that monarch was still an absolute monarch. They say the monarch was still an absolute monarch. Premnath calls for him. Premnath calls for him. Somewhat the purpose of the standstill agreement the purpose of what system would you have in the meanwhile? What system would you have in the meanwhile? State of the Raja of J&K didn't stand. Raja of J&K didn't stand. The records show there was some doing and throwing and eventually. The records show there was some doing and throwing and eventually. Which means as far as internal sovereignty is concerned. So as far as internal sovereignty is concerned. Because all the powers of the Maharajas and because all the powers of the Maharajas retain their internal sovereignty. Retain their internal. Now come to the merger agreement. Now come to the merger agreement. The merger agreement is important, my lord. The merger agreement is important, my lord. It finally indicates the external extent of internal sovereignty. External extent of internal sovereignty. If there was no standstill agreement, and if there was no merger agreement, and if there was no merger, Maharaja would be absolute, as Premnath calls. Maharaja would be absolute, as Premnath calls it. So I take 370 to be, my lord. So I take 370 to be, constitutional substitute, a constitutional substitute for a standstill in merger agreement. Without which, my lord, we are lost. Without which, my lord, we are lost. And I'll explore that, my lord, later when I come to 370. And I'll explore that, my lord, later when I come to 370. Your lordship also, my lord, put a question to Mr. Zafar Shah. Put a question that on the 4th of August. That on the 4th of August, what were the autonomies that you were allowed? What were the autonomies that you were allowed? You were going to lose. He promised you a list, my lord. One answer to that is everything. He promised you a list, my lord. I will indicate what these autonomies. But I will indicate what these autonomies meant. Which comes back to Justice Paul's question. Which comes back to Justice Paul's question: are we flogging a dead horse? The answer is no, my lord. It continues, and it has to continue. It continues, and it has to continue. The federation and the preserve, under which the federation and the conditions under which the federation. So let me begin with what I began with the other day. With what I began with the other day, we have the greatest diversity, and that is in the world. We have the greatest diversity. Many continents together. Take many continents together. Take many countries. This diversity is unparalleled. This diversity is unparalleled. That is why, my lord, Professor Ravinder Kumar. That is why, my lord, Professor Ravinder Kumar. What should I say in my Colombo lecture? I said, what should I say in my that the Constitution of India is a constitution that the Constitution of India is a constitution many nations for civilization and many nations and many cultures. And this is what makes our Constitution more exciting. And this is what makes our Constitution more exciting than any other. On the question of diversity, I was taking your question of diversity to, I was taking your lordships to, where is the other note? Where is the one other note? Just reading it. Just reading it. I have, my lord, done a list which I'll give to your lordships. My lord, done a list which I'll invite your lordships' attention. But I was going to invite your lordships' attention. Article 3 first. Article 3 first. of Article 3, my lord. All of Article 3, my lord. But I'm going to read one important aspect of it. And that is the proviso, which says that before anything is done under Article 3, it is mandatory for the president. It is mandatory for the president to the legislature to refer the bill to the legislature. It's a condition precedent before you invoke. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370, which have to be fulfilled, by condition precedents. Now on Article 3, my lord, the proclamation of 19th December created an amendment of Article 3 by taking the condition precedent out. Mr. Sybil read all that to you, but I want to refer your lordship to that particular part of the proclamation. That particular part of the proclamation. My copy, somewhere here. Your lordships will find this, my lord. Like Mr. Dwivedi, I have no problem with what your lordship is doing. We just have to learn and catch up your lordship is doing. This your lordships will find. In volume 3 documents.
Page 92.
And the PDF, my lord, I'll just give it to your lordships.
Page 92.
PDF 92. Now, my lord, I want to take your lordship straight away. And it's very important that we should.
Sanjay Miller. Page. Ultimately, everything boils down to this. Of course, the Constitution itself, and ultimately, everything boils down to this. Of course, one page the Constitution itself. In case something is missed, you can tell Mr. So far as documents are concerned, advocate, in one page put it in. In case something is missed, you can tell Mr. Dr. Dhawan's instructing advocate. They'll just put it in and the
Divine fire. Divine fire. Your Lordship will see that there is a condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO 48, which I'll show to your Lordships in a moment, in Article 3. And this condition precedent, my Lord, was added to by CO 48, which I'll show to your Lordships in a moment, my Lord, which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state, which further required. Now, my Lord, I take your Lordship sent to the legislature of the state, but we're not concerned with that. This notification sent to every single state. C subclause 2. Now, my Lord, I take your Lordships to this notification. C subclause 2. So much of the first proviso of Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, so much of and the second proviso to that article of Article 3 of the Constitution of 151 as relates to the reference by the President to the legislature of the state as relates to laying the second proviso to that article, so that much of the report clause 2 of 151 submitted by the governor to the controllers, my Lord, of the Constitution. As you will see that the opening sentence says the following provisions are suspended of the report submitted by the governor to the controller auditor general. In other words, my Lord, see that the opening sentence says of Article the following provisions are suspended, whether it applies to Kashmir or elsewhere, my Lord, is suspended. In other words, my Lord, a mandatory provision of Article 3 is not a question of just laying it applies to Kashmir Parliament as a substitute. Article 3 and Article 370 does not tolerate substitutes. It's not a question of just laying before Parliament as a substitute. No, my Lord, what does this do? Article 3 and Article 370 does not tolerate substitutes. That can be done under a proclamation. Under 356. No, my Lord, what does this do? It is a constitutional that can be done under a proclamation. Under which is subversive of the Constitution itself. It is a constitutional amendment. If this suspension fails, my Lord, which is subversive of the Constitution itself, and its extension, my Lord, in July will also fail. If this suspension fails, my Lord, President's rule will fail. You have amended the Constitution, and its extension, my Lord, in July will also certainly fail. To Jammu and Kashmir. And this mandatory provision, you have amended the Constitution, takes us to the core, albeit to all states and certainly the mandatory requirements, my Lord. And this mandatory provision, because the entire JK or takes us to the core, emanates from Article 3 and the mandatory requirements, my Lord, of Article 3. Because the entire take away this condition, my Lord, Reorganization
how
Act
deal with this,
emanates from Article 3 and Article 4.
1C?
Sorry, take away this condition, my Lord.
1C says, deal with this article that 356(1), he may make a proclamation where a situation has arisen that the government cannot be carried on in accordance with the provisions of this Constitution in any state, and then C, that if the
make such incidental and consequential provisions as appear to be the President to be necessary or desirable
Constitution in any state, and then C,
for giving effect to the objects of the proclamation, consequential provisions, including provisions for suspending in whole or in part the operation of any or desirable Constitution relating to any body, giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision
power
of
to
this
suspend
relating to any body
of the
or
Constitution
authority.
during
Right?
the operation of a proclamation under 356.
The suspension in this case goes beyond supplement.
So the President has a power to suspend.
It goes to actually taking out a mandatory provision.
During the operation of a proclamation under 356.
The suspension in this case goes beyond supplement, my Lord. It goes to actually taking out a mandatory provision. Of course, my Lord, Article 4 says that any change that is made will be treated as not requiring an amendment. But leave that aside, my Lord. How is 3 and 4 to operate after this? Article 4 says that any change that is made will be treated as not requiring an amendment. But leave that aside, my Lord. How is 3 and 4 to operate after this? The presidential duty, my Lord, has to be a little more careful because this was tailored way back in 19th December 2018 to start a process, my lord. The presidential duty, my lord, has to be a little more careful of amending the constitution for the purposes of which, because this was tailored way back in 19th December
Normally
2018
when the legislature, here of course it's the constitution,
to start a process,
uses
my
the
lord,
expression means and includes. Here it's not means, but
of
it says
amending the
make and
constitution
includes.
for the purposes
When
of
means
which
and includes is used by the legislature, it's an indication of
Normally
when the legislature, here of course it's the constitution. When the constitution says uses the expression means and or supplementary provisions, it's not means, but it says then says and includes. Including. When means and includes is used by the legislature, it's an indication of what was expanding the power stated earlier. Namely, so the earlier part says the constitution says it will make incidental or supplementary provisions.
Yes.
But then it says including. So including would mean that what was otherwise not a supplemental or incidental provision, the earlier part is within the ambit of the presidential proclamation, incidental or supplemental provisions. Because suppose that then it says including, just up to proclamation. Including would mean and didn't have what was otherwise not a supplemental it's including incidental provision.
Suppose
Ended with the word within the ambit of the presidential proclamation. So if the last part of Article 356 1C was not there, just up to proclamation, you could have challenged any amendment of the Constitution on the ground. It's not that you don't have the power to make an amendment to the word proclamation.
The operation of any provision
Or supplemental provision. If the last part of Article 356 1C was
in our
not there,
petition, we have challenged
you
only
could
the
have challenged
suspension.
any amendment of the Constitution on the ground. Suppose the president don't have the power to make an amendment to the operation of any provision of the Constitution. Incidental or supplementary. Is that amenable to a challenge on the ground that it is not incidental or
In our
supplementary?
petition, we have challenged
Or
only the
are
suspension.
these words of? My question is this: suppose widening the ambit of the first part of 356 suspends the operation of any provision of the Constitution.
This, my lord, has
Is that
remained
amenable
within
to a
the
challenge
limits
on the
of
ground that it is not
356.
incidental?
That is, for
or
the governor, you
supplementary?
read the president.
Or
For the
are
legislature,
these
you read the
words of
legislature. But I've never seen a provision in
Widening
any
the ambit of the
proclamation,
first
my
part
lord,
of 356 1B.
It-
So as to be immune
throughout,
from such a
my lord,
challenge.
these decades, which
within the
actually
limits of
uses the
356.
supplemental and
That is, for the
including.
governor, you read the president.
I've never
For
seen
the
it take
legislature,
away
you read the
a
legislature.
mandatory provision, but I've never seen a provision in any proclamation, my lord. This is exceptional throughout. Now you can read it together in one way, you can read it together in the other way. Uses the supplemental if you expand. I've never seen it take away a mandatory 356C, my lord. Then you will say that the president this is exceptional. Now you can read it together in one way, you amend any part of the Constitution as part of the supplementary. If you expand.
Can you, for example, say that there will be no judiciary in the state?
356C, my lord. Then you will say that the president has a carte
Right.
blanche.
Oh yes, the proviso
So,
says, of
Lord,
course.
So amend any part of the Constitution as part of the supplementary provision. Has to be read
Can you,
with the
for example,
mandatory
say that there'll
provisions
be no
which it
judiciary in
cannot
the state?
dilute. That's right, my lord.
That's what you are.
That may be covered by the proviso, but at any
Right.
rate.
Oh yes, the proviso
So,
says, of
Lord,
course.
supplementary, this 356C
But
has
actually
to
the
be read with the
proviso-
mandatory provisions which
Dr.
it
Dhawan,
cannot
the
dilute.
proviso seems to indicate that if Parliament, if the Constitution wanted to exclude a particular power from the authority to suspend a provision of the Constitution, Dr. Dhawan, then that has been specifically defined. Indicate. So the proviso says that you will not suspend if the Constitution wanted pertaining to a high court, a particular or you will not assume to yourself as the president authority to suspend a provision of the Constitution which are vested by the Constitution. Then that has been high court specifically during the operation of a proclamation and Article 356. Anything. So where it pertaining to a high court, introduce a restraint on the presidential yourself as the president has done so in the form of the proviso, which are vested by the Constitution. Do we now say that well, apart from the proviso, there may be certain other parts of the Constitution which the president cannot suspend.
No, that
So
is-
would that be reading into Article 356 words which are not the presidential power?
Lord,
It has done so in the form of the proviso.
Coupled with the words,
Do we now say that, well, apart
appears
from
to
the
the president
proviso,
to be
there may be
necessary
certain other
or
parts of the
desirable
Constitution
for
which the
giving
president
effect
cannot
to the
suspend?
objects
That
of
is
the
Or would that be
proclamation?
reading
Yes.
into
So
Article
there has to be
356 words
connect
which
in
are
a
not there?
nexus with the object
Lord, 356
of enforcing the proclamation. That's a restriction.
words. It must relate
Appears
to
the president to be
356.
necessary or desirable for giving effect to the object.
Words,
of the
whatever is
proclamation.
required to
So there has to be
materialize
connect in a
356,
nexus with the
it must be
object
related to
of
that.
enforcing the proclamation. That's a restriction.
It must relate to 356. And therefore, my lord, these words, necessary or desirable, is required to materialize powers of the president. It must be related to that. Under these provisions, suspended part 3. It has been done, my lord. And therefore, my lord, these words, necessary or desirable, are not directed principles. Could he have done all that, my lord? Could he have under these therefore, my lord, it has to be given even with the caveat of regards the High Court. It has to be given a limited meaning where your lordship finds fundamental rights. That in every state that has been created under Article 3 and 4, this has been treated as a mandate given even with the caveat of regards the High Court. It has to be given a limited meaning where your lordship finds on Article 3 that in every state all that it requires is a reference to the legislature. This has been treated as a mandate. Not bound by it. Those, my lord, when I do, there is a caveat that your lordships have imposed. I'll run through them very fast because I don't need to, my lord, on Article 3 out the books or refer to the cases. That all that it requires is a reference to the legislature. This, to my mind, my lord, is not bound by it. Taints the entire process. Come to my written submissions. I'll run through them very fast because I don't need to, my lord, take out the books or refer to the cases. This, to my mind, my lord, taints the entire process. Gopal Shankar Narayan, my lord. On the inclusion provisions for suspending in whole or in part the operation of any provisions of this Constitution relating to any body or authority of the state. Gopal Shankar Narayan, my lord. On the inclusion provisions for suspending in whole or in part the operation of any provisions of this Constitution relating to any body or authority of the state. Otherwise, my lord, 356 is an exception and then a colon. It overrides federalism. This further subscribes. It collapses democracy in a state. The presidential proclamation. Otherwise, my lord, 356 is an exception. It overrides federalism. It collapses democracy in a state. Because if the presidential proclamation does something that is irreversible, and that is a test your lordship will use. And Justice Khanna is right, my lord, when he emphasizes necessary or presidential proclamation does something that is irreversible and authority, and that is a test your lordship will use. If this proclamation is bad, then its extension, my lord, in July is also bad. Justice Khanna is right, my lord, when he emphasizes necessary or desire for the further 6 months. In relation to body and authority, as I pointed out, if this proclamation is bad, then its extension, my lord, in July is also bad, because that was a parliamentary extension for the further 6 months.
Yes.
Now, Lord, Article 358 suspends Article 19 during the proclamation, not beyond. This is now, my lord, and your lordships will see that further when I present CO 272 and 273. They go well beyond the period. Lord, Article 358, the genesis of all this, my lord, suspends Article 19 during the proclamation, not beyond. This is now, my lord, even assuming, my lords will see that further 1 year when I present, it takes away conditionalities which cannot be taken away. They go well beyond the period. And the genesis of all this, my lord, is the presidential proclamation. Even assuming, my lord, it goes for 1 year, it takes away conditionalities which cannot be taken away. Later, my lord, I'm sorry. I'm a little loud. I'm not used to whispering into microphones, like my predecessors. Now, my lord, I'm going to place. No, classrooms are very soft. I'm a little loud. Classrooms are a wonderful exchange into microphones. Unparalleled. Just as this is an exchange, like my predecessors, between the bench and us, my lord. And it is the nature of this exchange, my lord, place that we must honor. Well, under limitations of time, of course, my lord. But we must honor this exchange as the most important part of a wonderful exchange with students. Unparalleled. Just as this is an exchange between the bench and us, my lord. And it is the nature of this exchange, my lord, that we must honor. No, my lord. Well, under limitations of time, of course, my lord. But we must, my lord, honor this exchange as the most important part of arguing in this court. My lord, your lordships will see that because your lordship raised the question, what did you lose on 4th August, after 4th August? No, my lord, in Article 3, CO 48, the PDF is 485. CO, just want to point out the CO number. PDF 13. Lord, your lordships will see that because your lordship raised the question, what did you lose on 4th August, after 4th August? We're going to have nightmares about PDFs. The CO 48, the PDF is 485. Now, my lord, if your lordships were to come to page 10 of volume 3, take it out. 406, sorry, not external. Going to have nightmares about PDFs. PDF 13.
13? Same volume.
Same volume. Now, my lord, if your lordships were to come to page 10 of volume 3, 54 order. My lord, in a sense, the 54 order, 406 and 370, my lord, represents the Constitution PDF 13 as relates to Kashmir.
13?
They were brought in by the Constituent Assembly. Same one.
1954.
This is the
1954.
54 order. My lord, in a sense, the 54 order and 370, my lord, represents. Now, I'll just read out that particular portion the law as relates to Kashmir, so that I complete the 3-4 argument before I go. They were brought in by the Constituent Assembly. How elaborate our Constitution is. At the bottom of that page, my lord, 406, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and just read out that particular or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. How elaborate our Constitution is. It puts in a conditionality, at the bottom of that page, my lord, 406, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. Now, whether all this can be wiped out by CO 272 and 273 is another matter. I'm going to make one further proposition, my lord, about not just to circulate it, lest I forget, but I'll refer to it later, my lord. Conditionality, my lord, emanating from the state itself. Now, whether all this can be wiped out by CO 272 and 273 is another matter. I'm going to make one further proposition, my lord, about President's rule, lest I forget. I'll refer to it later. My lord, the further proposition, which is a wider proposition, is this: that during President's rule, Article 3 and 4 and 370 cannot be invoked.
Article
cannot be invoked. My lord, the further proposition, 3 and 4, wider proposition is why? Because they have conditionalities, my lord. That during the President's conditionality is specific to the legislature of the state. Article 3 and 4, the government of the state. 370 cannot be invoked. And the legislature becomes Parliament. The governor becomes the president. Therefore, the conditionalities that exist in 3 and 4 and Article cannot be invoked.
Article 3 and 4.
3 and 4, my lord. Neither, why? Because they have conditionalities, my lord. Nor the president. And the conditionality is specific to the legislature. Can be substitutes for the conditionalities the government of the state. And the legislature becomes Parliament. 3, 4 and 3 governor becomes the president. You don't go through that process. Therefore, the conditionalities that exist in 3 and 4 and Article 370.
With regard to Article 3, 4. Forget about 370 for the time being.
Parliament, my lord,
may not be correct in terms of the language used.
Can be substitutes for the conditionalities that exist.
Let's hope it never happens, but in a given case, it can happen.
3, 4 and 370. You don't go through that process.
Between two states and which is impossible to resolve regard to Article 4 steps in. Forget about 370 with regard to boundary or something.
If
so, broad proposition correct. If you're making a broad proposition like that, it's very difficult. P56. Let's hope it never happens, but in a given case, it can happen. Which we may not be able to postulate disputes.
Well, Lord, I'm making about
two states
proposition about process and
which is impossible to resolve until
because 370
with regard to boundary.
Subclause 1, my lord, has its
broad
discipline.
Proposition, don't. If you're making a broad proposition like that, read 370 for the time being, but a broad proposition that because we can be varied for the provisos can never be suspended in terms of Article 356.
My lord, the Parliament cannot be, and I'll show the debate when Amit Shah introduced this 370 in the Lok Sabha. Subclause Parliament cannot be a substitute for the legislature of the state. 3 and 4 has its mandate discipline.
Leave 370 for the time being, but a broad proposition that's
a very narrow
Article
proposition.
3 and 4, the provisos can never be suspended in terms of Article 356.
My lord, the Parliament cannot be, and I'll show the debate when Amit Shah introduced this. And when Mr. Sibal talked about the political uses and abuses of the legislature of the state, then Proclamation 19th December, my lord, is an abuse of the Constitution, and it would be a further abuse of the Constitution if we substitute for legislature Parliament.
Dr. Dhawan, there's difference between existence of power and abuse of power or use of power.
Of course, when Mr. Sibal talked about the political uses and abuses
there's a difference between existence of power or use of the power.
Proclamation 19th December, my lord, is an abuse of the Constitution, and it would be exercise is equally fundamental. If we substitute for legislation, we can't wish away the exercise as being purely nominal in nature. Of course, my lord.
So let's not confuse.
Now, my lord, when Maharashtra was broken,
There's a difference between
the
existence
judgments
of
are all
power
there in my written
or
submissions.
use
I'll
of the
take your
power or
lordship
abuse
very
of the
no,
power.
pass through
So
that.
let's not.
They said you have to refer whether you like it or not. Exercise is equally fundamental. You have to refer the bill to the legislature as being state. You can't self-refer it to parliament. Now, my lord, when Maharashtra was broken, in the judgments are all there in my written submissions. I'll take your lordship very fast through them. They said you have to refer whether you like it or not. The Constitution said no bill can be introduced, my lord. You have to refer the bill to the legislature of the state. Bargain. You can't self-refer it to parliament. The limitations of president's rule. And this is one of the important, my lord, limitations, that during president's rule, you may have the power to do whatever you want in 3, 4, and the Constitution says no bill can be introduced. 70. But the process, my lord, are conditions. It's a complete which can't be substituted by because we have to understand the limitations of the president and the legislature will become. This is one of the important. This process of substitution, my lord, during president's rule, you may have the power to do whatever you want in 3, 4,
can Parliament enact a law
70. But the process, my lord, are conditions
of a proclamation
which
under
can't
Article
be
356
substituted by simply
in
saying
exercise of the power under
the
Article
governor will now become the
246(2)
president
or in
and
respect
the
of a
legislature will
stateless
become
title.
parliament. Look, they can pass a law. This process of substitution, no doubt about that, subject to all the limitations that exist.
Right.
Except, my lord, there is
Dr.
when
Dhawan,
it
can
passes a
Parliament
law
enact a law
under Article 3 and 4,
during the
it must observe the
subsistence
conditions
of a proclamation under Article. In other words, what you are trying to in
Your
exercise of the
argument would
power
be
under
this,
Article 246,
that
while
to-
Parliament can
or
exercise
in
the
respect of a
lawmaking power
stateless
of
title.
the state legislature
Look, they can pass a law
during the subsistence
with all
of
its
the proclamation.
limitations. No doubt about that.
Yes, with all
Subject
its
to all the
limitations.
limitations that exist.
Right. The state list comes to
Except,
them.
my lord, there is
But
when
certain
it
other
passes
functions
a law
of the state legislature,
under Article
namely
3 and 4,
in terms of the first
it
proviso,
must observe the
to
conditionalities.
discuss, in other words,
A
what you are
legislative
trying to
proposal
for altering the
your
boundaries
argument
of the
would be
state.
this, or
That while
under the
Parliament
second
can
proviso for
exercise the
giving
lawmaking
consent,
power
that power
of the
can't
state
be
legislature
assumed by Parliament.
during the subsistence
With all
of
its
the proclamation.
limitations.
Yes, with all
The
its
state
limitations.
list comes to them.
The state list comes to them. But certain other functions of the state legislature,
Because then we are
namely
creating an
in terms of the
exception
first proviso, the language. I mean, you may possibly argue that you have to create that exception to give a purposive interpretation to that provision. Or under the second proviso
this
for
one-
giving
one part
consent,
is very clear,
that power
that
can't
to
be
accept
your
your
argument.
argument,
We are then creating an exception to 356(1)(b). Because 356(1)(a) says that the powers of the state government are vested in the president. Because then we are creating
in
the
the
governor,
exception.
as the proclamation would say.
not-
The language. I mean, you may
Other
possibly
than
argue
the
that you
powers
have
of the
to create that
legislature of the
exception to
state.
give a purposive
Then
interpretation to that
356(1)(b)
provision.
says,
But declare
This
that the
one-
powers
one
of the
part is very
legislature
clear,
of the
that
state
to
accept your
shall
argument,
be
we are then
exercisable
creating an
by
exception
or
to
under the authority of
356(1)(b). Because
So we will then,
356(1)(a)
to accept
says
your argument, we have to
that
then
the powers
hold,
of the
of course,
state
maybe by a
government
process
are
of
vested in the
construction,
president, that
or in the
those
governor,
powers
as the
which are
proclamation
referable
would
to
say.
Article 3 and 4, which are other than the powers of the legislature of the state. No doubt they are powers of the legislature of the
says
state.
the difference
Declare
between the
that the powers of the
legislative powers of the-
legislature of the state
and the
shall be
consultative and other
exercisable
powers of
by
the
or
legislature.
under the authority
If your
of
lordship
Parliament.
will see
So we
357,
will then, to accept your argument, we have to then hold, of course, maybe by a
But it
process of
says
construction,
declare
that the powers
those
of the
powers which are
legislature of
referable
the
to
state.
Article 3
Now,
and
which are the
4, which
powers
are-
of the legislature of the state, not just,
legislative powers.
not just the powers under Article 246, but it
powers
could
of the
be all the
legislature of the
powers
state.
of the
Difference
legislature of the
between the
state which are vested in
legislative
the
powers of the-
Constitution. Would that be not a more
And the
natural
consultative and
construction
other
that-
powers of the legislature. If your lordship will see 357, my lord, 357.
But it says declare that the powers of the legislature of the state. Now, which are the powers of the legislature of the state? Not just,
Legislative powers.
no, not
357(1), my lord,
246. But it could be
declares
all
that the powers of the
legislature
legislature shall
which are
be
vested in the
exercisable by or
Constitution. Would
under
that
the
be not a
authority
more
of Parliament.
natural
It shall
construction
be
that-
competent for Parliament to confer on the President the power of the legislature of the state to make laws and to authorize the President to delegate subject to such conditions as they may think fit the power so conferred to any other authority. For Parliament or the President or any other authority, my lord, in whom such power to make laws is vested, the powers of the legislature shall be exercisable to make laws conferring it shall be competent for Parliament to confer on the President and imposing the power of the legislature, authorizing the conferring to make laws, the imposition of and to authorize the Union or the delegate subject to such conditions and authorities thereof. Fit the powers of the President to authorize when the people, Parliament or the President or any other not in session, expenditure from the to make laws is vested under pending the sanction of such to make laws conferring. More important, the law is to and imposing duties. Any law made in the exercise of power, the imposition of the legislature, the union, or the officers, or the president and authorities thereof. Referred to the president to authorize when the people of which Parliament or the President not in authority would expenditure from the for the issue of the proclamation of 356 pending the sanction of such been competent to make after the proclamation has ceased to operate, continue in force any law made in the exercise of power of the legislature by Parliament or the President or other which is the competent legislature referred to in subclause so and so. Which Parliament or the President or such authority even as regards the function for the issue of the proclamation of 356 have been competent to make after the proclamation has ceased to they are specified operate, continue in force until altered or repealed or amended by a competent legislature. Which is the competent legislature? So, my lord, even as regards the functions of Parliament, they are specified 56 is not plenary in nature. It's important to understand that. It is the bane of the Indian Constitution, my lord. It's introduced again and again and again. In fact, the Indian Law Institute, I was reading the 1935 debates, my lord, where Churchill interjects and says, create the situation in every single province. Is not plenary in nature. No, my lord, it's important to understand has been used and abused. It is the bane of the Indian point where there must be some introduced again and again and again. It is certainly not, my lord, a power to amend the Constitution. In fact, the Indian Law Institute, I was reading the 1935 debates, my lord, where Churchill interjects and says, create the situation in every single province. Now, my lord, 356 has been used and abused to a point where there must be some discipline to it. It is certainly not, my lord, a power to amend the Constitution. Let's leave it there. Not transferring executive and parliamentary functions, that is the power to legislate alone, is the core of 356 and 357. There are many provisions in the Constitution, I have a list here, my lord, where legislatures exercise many other kinds of powers as well, my lord. Powers of election, powers of negation, powers of consultation. Not transferring, so it has to be limited, executive and parliamentary. Otherwise, my lord, that is the power to legislate alone. 5th August onwards, my lord, is the core of 356. Can happen to any other state during president's rule. There are many provisions in the Constitution, I have a list here, my lord, where legislatures exercise many other kinds of powers.
Legislatures exercise other
Powers of
powers,
election, powers of negation,
the other ones I
powers
just
of
missed that.
consultation. I have a list here. Article 3, for example, my lord. So it has to be limited, my lord.
Those other powers,
Otherwise, my lord,
you use that some phrase which I
what
just
happened
lost.
in
You said
the 5th
legislatures
August
exercise
onwards,
other
my lord,
powers.
there are legislative powers can happen to any other state.
That's
During
246.
Article 245, which says subject to the provisions of the Constitution. And it's important, my lord.
What are the other powers?
That is why the
consultative.
Article 3 is a consultative power to express
Consultation,
views.
which were the other ones I just missed
Article
out.
54 list here is the right to Article 3, for example, my lord, vote in presidential elections.
How do we conceptualize those other powers?
JK was not able
you
to
use that
participate, my
phrase
lord,
which
in
I
the
just
last
lost.
presidential
You
election.
said legislatures exercise other powers.
Article 80 is to elect members to the Rajya Sabha.
That's 246.
Article 245, which says Article 169 is to pass a resolution for the creation
What are the other
of legislative councils in the state.
consultative?
Article 3 is a consultative power to express views. Article 54, Article 171 is the right to 243M vote in presidential elections. I'll come to those because I want to go into the question of the diversity. JK was not able to participate, my lord, in the last presidential election.
243M.
Article 80 is to elect members to the Rajya Sabha. Then, of course, Article 169 is to pass a resolution for the creation of legislative councils in a state. Article 171, 243M. List of them, I'll give it to you. I'll come to those because I want to go into the question of the diversity. But the important part is it's limited to the legislative powers.
243M.
Then, my lord, 243M. It certainly cannot amend the Constitution. Most important, my lord. Or I'm going one step further, or deprive the Constitution of its mandatory processual requirements. It's an argument about process and power. A list of them, I'll give it to your lordships, my lord. I think it's better. But the important part is it's limited to the legislative power. And this, in my submission, my lord, it certainly cannot amend the Constitution. Taints or I'm going one extension of presidents or deprive the Constitution of its mandatory processual requirements. This is fundamental, my lord,
process
to
and
how this process of diluting 370 occurred and how Article 4, my lord, eventually got used with all these
this in my
incidental
submission,
provisions,
my
which
lord.
were limited to legislative powers and none other.
Now, my lord,
I wanted to get back to the point that I started
Against,
with,
my lord, also the
about the
extension of
diversity of the
President's
Indian
rule.
Constitution,
That
which
point
was
you
done,
have made, yeah.
done by Parliament, which I've already indicated to your lordship. This is fundamental, my lord.
I'll quickly
to
take
how
your
this
lordship's
process
through it.
of diluting
Because your
370
lordship is
occurred
concerned with how
and
this
how
diversity can be
Article
preserved.
4, my lord, eventually got used with all these incidental provisions, which
Bodoland,
were
my
limited
lord, is
to
mentioned in the
legislative
Constitution.
powers and none other. Nagaland has, Lord,
Now, my lord,
and others have
I wanted
autonomous
to get back to
councils.
the point that I
I
just
take your
started
lordship's
with,
Lord, about the diversity
Now, my
of
lord,
the Indian
if this
Constitution.
can be
done under President's rule, anything can happen. I'll quickly take your lordships through it. Yes, they look much. Because your lordship is concerned with how this diversity can be preserved. I've prepared a list of the articles that take us to diversity. I'll quickly run through them
my lord,
in
is
the
mentioned in the
Constitution itself.
Constitution.
I know your lordship doesn't like paper
has,
being handed
Lord,
over.
and
my
others
lord.
have autonomous councils.
I'll take your lordship.
But we can put it on the website, my lord.
Now, my lord, if this can be done under President's rule, anything can happen.
This is acceptable because these are only articles of the Constitution.
What I've done, my lord, to save time, is
My lord,
I've
it saves
prepared a
time.
list of the articles that take us to diversity.
permission is
I'll quickly
permissible.
run through them in the Constitution itself. I know your lordship doesn't like paper being handed over, my lord. Because when your lordship.
But we can put it on the website,
It's possible to give supplementary submissions. I thought that's a harshness that might be imposed on handing anything over to the court.
This is acceptable because these are only
Now, my lord,
articles of the Constitution.
come to Article 2, my
Quite
lord.
right, quite right.
This is
My lord,
important,
it saves
my lord.
time. It saves time. That permission is permissible.
It's Parliament's power
Because when
to
your
admit
lordship
to the Union new states on such terms and conditions as it thinks.
I thought that's a harshness that might
This
be
is
imposed
very, very
on
different,
handing
my lord.
anything over to the court. From the assimilation, my lord, of the
Now, my lord,
princes, etc., into the
Come to
Constitution.
Article 2, my lord.
That is, you go through.
This is important, my lord.
An instrument of accession, you go through standstill, you go through merger,
It's
which then
Parliament's
determines
power
what is really entered into.
to admit to the Union new states on such
Of course,
terms
my lord,
and conditions
in Podial's
as it thinks
case,
fit.
the majority
This is
judgment of
very,
Justice
very
Venkatachala
different, my
Iyer
lord.
takes into account the entire history of the negotiations
From the
and
assimilation,
says that
my
although
lord,
the
of the
Constitution
princes,
says
etc.,
one
into
person,
the
one
Constitution.
vote, that is,
Nevertheless,
you
we
go through
will permit
an instrument
reservations
of
for
accession,
Bhutia's
you
left
go
hand
through
and the son. In the context of
standstill,
that
you go through
history, we
merger,
will nevertheless permit.
which then determines
And there were two
what is
dissents, my
really
lord.
entered into by Chief Justice Sharma and Justice
Of course, my
Agarwal.
lord.
In Podial's case,
Now, Podial reminds
majority
us that
judgment
these
of
negotiations
Justice
are
Venkatachala Iyer
important. Takes into
even
account
though
the
it
entire
says
history of the negotiations.
2A
And
was
says that
removed,
although the
Constitution
says one
because
person,
Sikkim
one
was
vote.
given associated.
Nevertheless,
we will statehood first.
Permit. Now, my lords,
reservations for
kindly come to
Bhutia's
3,
left
which
hand
I've dealt with, 3 and 4. In the context of that history, we will nevertheless permit it.
And there were two dissents, my lord.
Then, my lord, kindly come
Chief
to
Justice Sharma and Justice
a very
Agarwal.
interesting provision, my lord.
Now, Podial reminds us that these negotiations
When we
are important. Dealing
Even
with
though it says as
affirmative
it
action.
thinks fit.
That's
2A
Article
was
35,
removed,
my lord, in the Constitution because Sikkim was given associated statehood first.
Now, my lords, kindly come to 3, which I've dealt with, 3 and 4.
Prepare a proper list. Identify to be one.
Then, my lord, kindly come to a very interesting provision, my lord.
Now, this is a very interesting provision, my lord, when we were dealing with
Relating to
affirmative
Article
action.
16.3.
That's Article
I'll just
35.
read it, my lord, because it's important. Notwithstanding anything in this Constitution, Parliament shall have, and the legislature of a state shall not have power to make laws with respect to matters in Article 16.3, 32.3, 33, 34, or for prescribing punishment
Now, this
for
is a
those
very
acts which
interesting
are declared
provision, my
offences
lord.
under this part. And Parliament shall,
Relating
as
to
soon
Article
after the
16(3),
Constitution, make laws.
I'll just read
prescribing
it, my lord,
punishment.
because it's important.
Laws notwithstanding anything in
Now,
this
here's a very interesting
Constitution,
provision, my lord.
Parliament
In relation
shall
to
have,
affirmative action,
and the
the
legislature
power
of
of the
state
legislature
shall
is
not
taken away.
have power to make laws with respect to matters.
To change this, my
in
lord,
Article
would require
16(3),
an amendment to the
32(3),
Constitution.
33, 34,
Two judgments have dealt
or
with
for
it, my lord.
prescribing punishment for those acts
Starting-
which are declared offences under this part.
which have dealt with
And
not
Parliament
Andhra
shall,
Pradesh and
as soon
Jharkhand.
after the
But we needn't go into
Constitution, make
that.
laws prescribing
Then,
punishment.
my lord, if your lordships will
Laws
come
immediately
to
to Article
Article
164.
164 provision, my lord. In relation to affirmative action,
All done.
the power of the legislature is taken away. I pointed this out on the other day, my lord. To change this, my lord, would require
These
an
are
amendment to the
safeguards, my
Constitution.
lord, for the federal
Two
unity
judgments
of
have
India.
dealt with it, my lord. Starting,
Which have dealt
as
with
indeed
not,
was
Andhra
370
Pradesh and
for the
Jharkhand.
federal unity of
But we
India.
needn't go into that.
Then, my lord, if your lordships will come to Article 164.
Got it. All
It
done.
is part of the basic structure of federalism in our Constitution. I pointed this out on the other day, my lord, when I was formulating this argument.
These are
I was
safeguards,
told
my
the
lord,
lordships might be
for the
averse to a
federal
basic
unity
structure
of
argument,
India.
so don't make it too strongly. So I'll stay within my limits, saying
These
these
are
are limits that
370
the Constitution
for the federal
has
unity of
in
India.
relation to federalism. Now, 164, my lord. I've given your lordships a list. I'm going around the list where taking your lordships to part of the basic structure of federalism in our Constitution. When I was formulating this argument, I was told their lordships might be averse to a basic structure argument, so don't make it too strongly. So I'll stay within my limits, saying these are limits that a Constitution has in relation to federalism. Now, 164, my lord. I've given your lordships a list. I'm going around the list where taking your lordships through the important provisions. Article 164. My lord, has a proviso. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in charge of tribal welfare who may, in addition to be in charge of the welfare of scheduled castes and backward classes or any other work. My lord, this, if it is to be changed, requires a constitutional amendment. Proviso. Can't be done under president's rule saying we will have this minister or that minister. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, then, my lord, there shall be a minister in charge of tribal welfare who may, in addition to be in charge of the welfare of scheduled castes and backward classes or any other work, which empowers the legislature, my lord. Much in the same way, my lord, as the JK Constitution, if it is to be changed, requires a constitutional amendment. Article 169, my lord, can't be done under president's rule saying we will have this minister or that minister. 168 and 169. Then, my lord, if I may take my lords, my lord, to 168. This relates, my lord, to whether there should be two houses in Parliament the legislature, my lord. Finally, bear in mind, much in the same way, my lord, as Jammu and Kashmir had a legislative council, empowered the legislature under its constitution. Article 169, my lord,
168 and 169. I'm reading, my lord, 169(1). Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state, having such a council, or for the creation of such a council, 2 houses in Parliament in a state having no such council, if the Legislative Assembly had a legislative of the state passes a resolution to that effect by a majority of the total membership of the Assembly and 2/3, my lord, of those present and voting. I'm reading, my lord, 169(1). Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state, having such a council, or for the creation of such a council, the JK Constitution is in a state having no such council, if the Legislative Assembly of the state passes a resolution, then the Lord kindly come to by a majority of the total membership of the Assembly and 2/3, my lord, of those present and voting. In our case, my lord, I earlier said, my lord, the other day, well, actually the whole of the JK Union territory is gone. Where was the power other than Chandigarh were created by constitutional amendment? Then, my lord, kindly come to, or under the aegis of a constitutional amendment, like the 6th Amendment. (239A), my lord, deals with how union territories are to be created. I'd earlier said, my lord, the other day, and the creation of local legislatures. This can't be given the go-by. Chandigarh were created by constitutional. Parliament may by law create for the union territory, or under the aegis of a constitutional amendment, like a body elected partly or partly nominated, partly elected to function as a legislature and a council of ministers, or both with such constitution powers and functions. 239 in each case may be specified. Deals with how union territories compare with what has happened in the case of J&K. State and the creation of union legislatures. 2 union territories, the go-by, one without a legislature, one with. Parliament may by law create for the union territory of Puducherry, this a body was not within the remit of Article 3 and 4 to function as an incidental council of ministers, or both lose your character as a state functions. And there are 2 union territories that have been created, not by reference to Article 239A. State or 239A union territory. If you wanted an elaborate constitution put in place, 2 union territories, as in the JK Reorganization Act, you should have done what is done with Delhi. This was not within the remit of Article 3 and 4 as an incidental provision, my lord, where you lose your character as a state. And there are 2 union territories that have been created, not by reference to Article 239A. Your lordships are very familiar with the 2 Delhi judgments, my lord. I'm not going to take. If you wanted I'm going to refer to passages of it because they deal with diversity. As in the JK when I read my written submissions, my lord, you should have done what is done. I won't have to ask your lordships to PDF. Now, my lord, come to Article 240. Power of the president to make regulations for certain union territories. Now, my lord, your lordships are very familiar with the 2 Delhi judgments, my lord. I'm not going to take. I'm going to refer to passages of it because they deal with diversity. But when I read my written submissions, my lord, they'll be there. I won't have to ask your lordships to PDF. Now, my lord, come to Article 240. Because if 240 is applied to JK, as it must be, my lord, it's a union territory now. Power of the president to make regulations for certain union territories. But, my lord, the president will make regulations for peace, progress, and good government of union. Do we add JK, my lord, and Ladakh to it? Is this applicable, my lord? If so, my lord, it's a, because if 240 is applied to JK, not just federalism, it's a union territory, but democracy itself. Or perhaps that has to be added by constitutional amendment. But, my lord, the president will make regulations for peace, progress, and good government of union territories. Now, my lord, may I take your lordships to 243, particularly to 243M and 243ZC. It undermines not just federalism, my lord, but democracy itself. Now, my lord, may I take your 243, particularly
M says
243 M
Panchayat,
and 243
so
ZC
fundamental to three-tier federalism, shall not apply to certain areas. I'm just showing the diversity, my lord, that exists. Now, my lord, if your lordships will come to subclause 2(3)(a), this will not apply to the district of Darjeeling of West Bengal,
M says
for which
part
the Darjeeling
Panchayat,
Gorkha Council
fundamental
exists under any law for the time being in force.
shall not apply
Even the Panchayat
to certain
amendments
areas.
have been curtailed in this balance of federalism. I'm just showing the diversity, my lord,
Not,
that
my lord,
exists by any executive exercise.
Now, my lord, if your lordships will come to subclause, and then, my lord, 2(3)(a), that it won't apply
not
to
apply to
Arunachal
the
Pradesh,
district of Darjeeling of West Bengal, for which the Darjeeling Gorkha
And then once
Council
again, my lord,
exists under any
here
law
is
for the
a
time being.
non-legislative function.
Even the
my lord,
Panchayat amendments, my lord, have been curtailed
in Article
this
4.
balance of federalism.
Legislature of the state may
Not,
by
my lord,
extend this
by
part of
any
the state
executive
except the
exercise.
areas referred to in clause 1. If the legislative assembly of that state passes a resolution 3(a)
to that effect by a majority
that
of the
it
total
won't apply
members
to
of the House,
Arunachal Pradesh,
and by a majority of not less than 2/3.
here is once again
And
a
then once
provision,
again,
my
my
lord,
lord,
the most
here is
fundamental
a
exercise of
non-legislative
three-tier
function, my lord,
federalism, my lord,
which is a part of our constitution.
in Article 4. Legislature of the state may by extend this part to the state except the areas referred to in clause 1. If
Then, my
the
lord,
legislative
ZC,
assembly of that state passes a
243 ZC
resolution
says the same thing,
to
my
that
lord,
effect by a majority of the total
about the
membership of
Delhi,
House,
Darjeeling
and by a
Gorkha
majority
Hill
of not less
Council.
than 2/3.
Here is once again a provision, my lord, the most fundamental exercise of three-tier federalism, my lord, which is a part of our constitution.
First, my lord, 243 ZB, my lord, which is about municipalities.
It applies to union territories.
Then, my lord, ZC, 243 ZC says the same thing, my lord, about the Delhi,
which have a
legislative
Darjeeling
assembly.
Gorkha Hill Council. What happens to Ladakh?
ZC, my lord, first, my lord, has
243
similar
ZB,
provisions,
my lord,
which is about municipalities.
as it does to panchayats. It applies to union territories.
In relation to the Darjeeling Gorkha Hill Council, which have a legislative assembly.
What happens to Ladakh?
ZC, my lord, has similar provisions.
275, my lord, very
As
fast.
regards municipalities as it does to panchayats.
Sorry, 244, my lord.
In relation to the Darjeeling Gorkha Hill Council.
This is, my lord, dealing with scheduled and tribal areas.
275, my lord, very fast.
None of this can be wished away, certainly not by executive action. My lord.
Sorry, 244, my lord.
It is so crucial to understand this diversity of our constitution.
244 says, administration of scheduled areas and tribal areas shall apply to the administration and control of scheduled areas in any state other than the states of Assam, Meghalaya,
This is, my lord,
Tripura, and
dealing with
Meghalaya.
scheduled and tribal areas. None of this can be wished away, certainly not
is
by
a very important
action.
provision, my lord.
It is so crucial to
Because it
understand
relates to autonomous
this diversity
states.
of our constitution.
244
Our
says,
constitution, my lord, doesn't shy
administration of
away from
scheduled
creating
areas and tribal
autonomous
areas
states, my lord.
shall apply to the administration and control of scheduled areas in any state other than the
there was
states
that
of
measure
Assam,
of autonomy, my
Meghalaya,
lord, in
Tripura,
JK,
and Mizoram, then it is not inconsistent with so many provisions in our constitution.
which
then
respect
244A
autonomy for what
is a
it's
very
worth in
important
special
provision, my
areas.
lord.
Because it relates to autonomous states.
244A,
Our
my lord, is very
constitution, my lord,
important.
doesn't shy away from creating.
And when I come to
autonomous
Schedule
states,
6,
in fact, if this can be done, my
that.
lord, under president's rule, place any under president's rule, expand
And
it
if there
beyond
was
the
that
measure
legislative
of autonomy, my lord,
simply
in
can't be
JK.
done, my lord.
These are mandatory
It is not
provisions of the
inconsistent
constitution.
with so many provisions in our 244A,
Constitution,
formation of an autonomous
which
state
respect
concerning
autonomy for
tribal
what
areas
it's
in
worth in
Assam
special
and the
areas.
creation of local legislative council. Parliament may by law from within the estate of Assam, an
244A, my
autonomous
lord, is
state
very important.
comprising whether wholly in part
And
of
when I come
tribal
to
areas.
Schedule 6, because if this can be done, my lord, under president's rule, place any under president's
Autonomy,
rule, expand
my
it
lord,
beyond the
of the
legislative
states
council.
is
Simply can't
fundamental
be done,
to our
my lord.
constitution.
These are mandatory
provisions of the
I
constitution.
rely on the
244A,
judgments,
formation
my
of
lord,
an
of your lordship,
autonomous state concerning tribal areas in
reinforce this.
Assam and the creation of
where your
local
lordship
legislative
respected, my
council.
lord,
Parliament may by
the
law
autonomy of the
from
legislature
within the estate of Assam
their
and an
existence.
autonomous state comprising
Those
whether wholly
passages
in
I'll show
part
to your
of
lordship
tribal
very
areas.
fast, my lord, because they're in my written submissions. Autonomy, my lord, is not
Autonomy,
alien to
my
our
lord,
constitution.
of the states is
You
fundamental
can't just
to our
standardize, my
constitution.
lord, all the provisions and say,
I
look,
rely
we
on
give
the
autonomy here, but
daily
we're not going to
judgments,
give
my lord,
autonomy
of
to
your
J&K. Why? Because
To
on 19th
reinforce this.
December, we took away a provision where your lordship respected, my lord, the autonomy of the
J&K
legislature
is not a
dead horse, my lord,
and
to
their
be flogged or
existence.
not to be flogged. It
Those
is
passages I'll
the
show to your lordship
constitution
very
of
fast,
an
my lord,
autonomous
because they're in my
region.
written submissions.
Through the merger agreements which are autonomy, my lord, is not alien to our
I'll come to
constitution.
370 in a moment.
You can't
It's
just
very important
standardize
to
to
understand
understand and not wish
and say,
away
look,
the
we give
autonomy
autonomy
here,
in-
but we're not
in
going to
Indian
give autonomy to
federalism.
J&K. Why?
Then, my lord,
Because on 19th
if I may
December,
take your
we
lordship,
took away
my
a
lord,
provision.
to 275.
J&K is not a dead horse, my lord, to be flogged or not to be flogged. It is the constitution of an
It has
autonomous
special
region.
provisions, my lord, made in
Through the merger
275.
agreements which are part of 370.
I'll come to
Subclause
370 in a
1A.
moment.
It's very important to understand and not wish away the autonomy in Indian federalism.
Then, my lord, if I may take your lordships, my lord, to 275.
Can I tell them you are my guru?
It has special provisions, my lord, made in 275.
Subclause
Now, my lord,
1A.
kindly see
What happens to the disbursement of grants
to autonomous states.
in 275 1A? Can I tell them you are my guru?
Now, my lord, kindly see
What happens to the disbursement of grants
to autonomous states, my lord, 279A,
which
in
is the GST
275
amendment 1A?
I put it in summary form, my lord, in the table so that it will be a little easier for your lordships. Even in the distribution, my lord, as far as the GST applies, 279A subclause 4G says special provision, sorry, next, my lord, 279A,
Which is the
I'm
GST
sorry, my
amendment.
lord, where I put in my chart 279,
I put it
it should say
in summary form, my lord, in
279A.
the table so that it will be a little easier for your lordships.
Even in the distribution, my lord, as far as the GST applies,
Now, my lord, G is a
279A
very,
subclause
4G is a very
4G.
interesting proposition.
Special provision went to be made to the states of Arunachal,
Says special
Assam,
provision,
Jammu and Kashmir, Manipur, Meghalaya, Mizoram,
I'm sorry, my lord,
Nagaland,
where I
Sikkim,
put in my
Tripura,
chart,
Himachal Pradesh,
279,
and Uttarakhand.
it should say 279A.
This must be on account of geographical reasons.
Sorry, my lord.
This must be on account of geographical reasons. All these are really states.
Partly that and partly because of the nature
G
of
is
the
a very,
states.
4G is a very interesting proposition.
But this can be
Special
reversed
provision
and
will
it
be
will be
made to
placed
the
before the
states of
GST,
Arunachal, Assam,
because it lays
Jammu and
later
Kashmir,
on that the
Manipur,
GST
Meghalaya,
Council
Mizoram, Nagaland, Sikkim, Tripura,
will look at
Himachal
this.
Pradesh, and Uttarakhand. Now, my lord, I come to Article 330.
This must be on account of geographical reasons.
Sorry, my lord.
This must be on account of geographical reasons. All
Very
these are really
important
states.
provision, my lord. Partly
To
that
say
and
that
partly because
special
of the nature of the
provisions can't
states,
be made in the
right now.
Constitution is anathema.
But this can be reversed and it will be placed before the GST, because it lays later on that the GST Council will look at this. Now, my lord, I come to Article 330. Very important provision, my lord. To say that special provisions can't be made in the Constitution is anathema, my lord. Now, my lord, these special provisions relate to certain classes. Scheduled caste, scheduled tribes, Anglo-Indians, etc. Special provisions are a regular feature of our Constitution. I don't want to take your lordship through this, but these special provisions exist, without which, my lord, so much could not be done for the SC, ST or the OBCs. Now, my lord, these special provisions relate to certain classes. In fact, all these commissions, my lord, they report tribes, Anglo-Indians, and when the government special provisions are a regular feature of our Constitution, that it shall be laid before the legislature of the state, these special provisions with a memorandum, without which, my lord, the action taken or proposed to be taken on the recommendations relating to the state reasons for the non-acceptance. This is, my lord, 338(7). This is what should be done with President's rule, my lord. In fact, all these commissions, my lord, even the governor's report, my lord, was not. And when the government of the state, this is what has to be written in, just as your lordship in Nagraj added conditionality for the legislature of the state. This is what should be written with a memorandum. The action taken or proposed. You put in all the information you have relating to the state. You put in the governor's report reasons, and you give the reason for the non-acceptance. This is, my lord, 338(7). This is what should be done with. Otherwise, my lord, 356 has become a farce. Even the governor's report, my lord, was not placed. When I was doing my book on President's rule, this is what has to be elaborate discussion on Kerala Nagraj. When they added conditionalities, my lord. President's rule. This is what should be written into. As we come down the line, there is hardly any discussion. You put in all the information you have. Why? Because all the information is not even there. And you give the reasons. And in the case of Jammu and Kashmir, it wasn't there. The entire correspondence. Otherwise, my lord, 356 has become. I'm just building, my lord, something that is here in 338. When I was doing my book on also for the other commissions, the elaborate discussion on something, Kerala, my lord, that gives information to the people, President's rule, and those people who have. As we come down the line, there is hardly any discussion, or unblessed as the case may be. Why? Because all the information is not even there. That entire cache of information of Jammu and Kashmir, which is so fundamental, my lord, to democracy. The entire correspondence is missing in the proclamations. I'm just building, my lord, something that is here in 338. Then, my lord, 7, if I may take, which is also for the other commissions, my lord, to an interesting provision, something, my lord, that gives 330, my lord, to the people, which makes special provision for reservation of scheduled castes and scheduled tribes, blessed or unblessed as the case may be.
We saw 330. We've seen 330.
That Assam is mentioned. Cache of information. 343, which is so fundamental, my lord, to democracy and federalism, is missing in the proclamations. Then, my lord, if I may take my lord, this has to be read with the 8th schedule. 330, my lord, is one of the languages special provision for reservation of scheduled castes and scheduled tribes. So in communications, in complaints, etc., Assam is mentioned. Kashmiri can be used. That has not been taken away and cannot be taken away. Part of the spirit, my lord, of a region or a state is its language.
This has to be read with
Now,
the
my lord,
eighth
your
schedule.
lordships, when you look at the
Kashmiri,
language
my
of the
lord, is
union,
one of the languages recognized by the eighth schedule. Finally,
commission
just
is
read this.
appointed.
So in communications, in complaints, etc., Kashmiri can be used.
347
That
makes
has not been taken away. and
special
cannot be
provisions
taken away.
for language spoken by a
Part
section
of the
population.
spirit, my lord, of a region
And
or a
of course,
state
my
in
lord,
this language.
Chapter 4, that's 350. Now, my lord, your lordships, when
Has
you
special
look at the
directives
language
in
of the
relation
union,
to language. Who is going to
Commission
make
is
those special
appointed.
directives now? The president? Parliament? What is the status of Kashmiri
347
now, my
makes
lord? Does it
special
disappear from the
provisions
eighth
for
schedule?
language spoken by a section of the population. And of course, my lord, Chapter 4, that's 350.
Then, my lord,
371A,
special
my lord,
directives in relation to
has a
language.
very interesting provision. 368,
Who
my
is
lord,
going to make those
I've
special directives?
kind of dealt
now?
with, my lord.
The president? Parliament?
So I won't take your lordships to that. But
What
371.
is the status of Kashmiri
A,
now, my lord? Does it disappear from the eighth schedule, my lord?
Then, my lord, 371A, my lord, has a very interesting provision.
It is a very interesting
368, my
provision,
lord,
my lord.
I've kind of
All
dealt
this
with, my
discussion
lord.
on the Uniform Civil Code.
So I won't take your lordships to that.
These are also
But
unamendable
371
provisions, my lord.
A, my lord.
Just as we are arguing that 370 was unamendable, my lord, by 368, subject to a certain procedure.
A says, notwithstanding anything in this constitution,
It is a very
no
interesting
act
provision,
of parliament in respect of the religious and
discussion
social
on the
practices
Uniform
of the
Civil
Nagas,
Code.
Naga customary law and procedure, administration of
also
civil and criminal
unamendable
justice
provisions.
involving decisions according
Just
to
as we are
Naga
arguing
customary
that
law
370
shall apply to the
was
state of
unamendable, my lord, by
Nagaland
368,
unless the
subject to a
legislative
certain
assembly
procedure.
of Nagaland by a resolution so decides.
Non-legislative power.
371A says, notwithstanding
is
anything
repeated,
in
my
this
lord.
constitution,
The
no
important
act of
provision, my lord.
parliament in respect of the religious and social practices of the Nagas, Naga customary law and procedure, administration of civil and criminal
371, of
justice
course, concerns the
involving
hill areas of
decisions
Manipur.
according to
Very
Naga
relevant.
customary law, shall apply to the state of Nagaland unless the legislative assembly of Nagaland by a resolution so decides.
Non-legislative power. My learned friend has a point that if there is president's rule
And the
the
same is
legislative
repeated, my
assembly
lord.
has this power,
The
can
important
parliament
provision,
that is why, my lord, it is restrained
capital
in
F,
356.
subclause F.
Now, my lord, the
This is
controversial
provision
provision
on
on
which
which your lordship has given a judgment. If I have time, my lord,
Is
I'll take your lordship's
371
word. If not,
F.
my lord, I'll just refer to paragraphs.
Capital F, subclause F. Parliament, for the purpose of protecting the rights and interests
This is
of different
cordial, my
sections
lord.
of the population of Sikkim,
If I have time,
may
my
make
lord, I'll take your
provisions for the
lordship's
number
word.
of
If not,
seats
my
in
lord,
the
I'll just refer to
Legislative Assembly of
paragraphs.
the state of Sikkim, which may be filled by
Parliament,
candidates
for the
belonging
purpose
to
of such
protecting the
sections,
rights and interests
for
of
the
different
delimitation
sections
of the
population of Sikkim,
constituencies,
may make
which
provisions for the
candidates
number
belonging
of
to
seats
such
in the
sections
Legislative
alone
Assembly
may
of the
stand
state
for
of Sikkim,
election
which may
to the
be filled by
Legislative Assembly.
candidates belonging to such
This, my
sections.
lord, was
For the
examined in
delimitation
Podia.
of the assembly
I'll give your
constituencies
lordships a reference
and
note
from which
Podia,
candidates
Your Honor.
belonging to
Which
such
volume is it
sections
in?
alone may stand
It's
for
in volume
election
14.
to the Legislative Assembly.
This, my lord, was examined in Podia. I'll give your lordships a
The
reference
argument
note.
was a very
Podia,
interesting
Your Honor.
argument.
Which volume is it in? It's in volume
Baba Saheb
14.
Ambedkar
itself said in Parliament that there will be one person, one vote. Apart from the reservations.
The argument was a very
interesting argument. my lord. So the argument that was advanced, my lord,
Baba Saheb
which
Ambedkar
led to
itself
a
said in
3-2
Parliament
decision that there will be one person,
was
one vote. That although this is their
apart from
part
the
of the
reservations from
constitution,
SC,
we have to take the history of Sikkim into So the
account.
argument that was advanced
And
my lord,
reservations
which
for
led
Bhudias,
to lectures in the
a
sun
3-2 decision
optimism, was that
This, your
although
lordships,
this is
my lord,
their part of the
will find
constitution,
in volume
we have to
14.
take the history of Sikkim into account and
6350.
reservations for Bhudias, lectures in the sun optimism.
This, your lordships, my lord, will find in volume 14. We want
The majority starts at 6350. Mandatory provisions respecting, my lord, what the people of Sikkim had asked for. The majority starts at 6392, my lord. Albeit, my lord, with adjustments to the constitution. Mandatory provisions respecting, my lord, what the people my lord, of Sikkim while you're on it, will your lordship just turn to Podial, my lord, because it's important to bear in mind. Albeit, my lord, with adjustments to the constitution. PDF kya hai? No, my lord, while you're on it, will your lordship just turn to Podial, my lord. Volume 14, 305, bear in mind. Starts it, sorry.
Volume 14, page
Cases volume
30.
305. Volume 14, 305. Starts it, sorry.
Volume 14, page
Cases volume
30.
So, my lord, if your lordships will turn to 6394, my lord, which is PDF 349.
Where does it actually begin?
If your lordships will
yes,
turn
I got it.
to 6394.
It begins at 305.
Where it starts, which is
Yes.
PDF. And I'm referring to the discussion in
PDF
349.
Where does it actually begin, the judgment? Yes, I got it.
Sorry, my lord.
It begins at 305.
At PDF 349. Where it starts.
Yes.
And I'm referring to the discussion in Chief Justice Venkatachalaiya's judgment, my lord. At PDF 349. Okay, I'm on 36394, which is PDF 249, 349. Now, my lord, here, I'll go through it very, very quickly. Just learned Chief Justice, my lord, which is PDF, goes from para 66 on 349. Now, my lord, here, proclamations I'll go through it very, very quickly. Just the learned Chief Justice, my lord, goes from para 66 onwards, 76, to all the proclamations and discussions. '74 in particular, my lord, at page 676, my lord. The year 1973 saw the culmination of a series of successive political movements. 74 in particular, towards the government responsible to the people. Then it mentions the tripartite agreement. The year 1973 is mentioned there in culmination of a series of successive political movements. And in Kashmir towards the government responsible to the people. Other provisions. Then it mentions the tripartite agreement, clause 5 of which is mentioned there in para 74. And various other provisions are made. He actually deals with welfare. He actually says, just give me a moment. Where he actually deals with what they are. Where he actually says, just give me a moment. 120. Para 120, Lord.
Of the judgment?
PDF 364. 120. Why was this, Lord, promise to the people honored despite a provision of the Constitution?
Of the judgment?
PDF, and this is explained by the majority. Why was this, Lord, promise to the people honored 409 despite a provision of the Constitution? PDF, and this is explained by the majority. Para 120. At para 120, 6409. PDF, what was the rationale, my lord, of respecting what the people of Sikkim wanted, 120, despite the provision in this constitution, one person, one vote, and no vote on account of religion? What was the rationale, my lord, of respecting the rationale and constitutionality of clause F and other provisions in this constitution, impugned in these conditions are sought to be justified by the respondents on grounds that a perfect arithmetical rationale and constitutionality or value of votes is not other provisions of the electoral law imperative of democracy. And second, even if the impugned provisions make a departure from tolerance limits, perfect and constitutional and the constitutional permission, value of votes permissible limits, the discriminations imperative of democracy. And second, even if the impugned provisions make a departure from tolerance peculiar to and constitutional and the constitutional permissible limits, the discriminations arise are justice of the historical conditions and the characteristic of the evolution of Sikkim's political institution. Therefore, my lord, your lordship has been taken into Sikkim's political discussions that were held as far as and the characteristic of the evolution and why it is important, particularly as I indicated. Therefore, my lord, your lordship has been taken into which deals with discussions that were held as far as unlike my lord, sir. The instrument and why it is important deals with particularly as I indicated, the merger agreement. The last four lines are deals with internals of what article unlike 120, 371, the instrument of accession and the electoral laws in relation to Sikkim seek to provide the last is to maintain this balance in the peculiar historical 120, 371 the development of Sikkim and the electoral laws in relation to Sikkim seek to provide Sikkim is the only other is to maintain this balance where it in the peculiar historical setting. And therefore you take into account all the antecedent discussions and see if they make up Sikkim is the only other example we have other than Kashmir. Whether for 370 or entered into Manod. And therefore you take into account all the antecedent discussions and see if they make up the case. Put some whiskey in it. Whether for 370 or otherwise. In my voice. I take your lordships, my lord, to Schedule 5. Put some whiskey in it. I'll skip, my lord, the... Now, my lords. I take your lordships, my lord, to in the Schedule 5. I'll skip, my lord, the... in the Constitution. Schedule 5, my lord, deals with the administration of scheduled areas and scheduled tribes. Some of us are not happy with the Constitution Bench decision in Chebrulu, my lord. Schedule 5, how you apply legislative powers. Deals with my lord, there's a tribal scheduled advisory council. Some of us are not happy with the Constitution Bench decision in Chebrulu, my lord. So when the governor, my lord, applies laws under 5 subclause 2, there's a tribal advisory council. So when the governor, my lord, applies says no regulation under 5 paragraph 2, unless the governor making the regulation has in the case where there is a tribal advisory council consulted such council. 5 says no regulation under this paragraph. But this is in unless the governor making the regulation has in the case where there is a tribal advisory council consulted such council.
Where is that, Dr. Dhawan?
My lord, this is in subpara 5, my lord.
Of consultation with the Tribes Advisory Council.
Now here, my lord, even with there is power, you must consult the Tribal Advisory Council.
Consultation with the Tribes Advisory Council.
Now here, my lord, then my lord, I come to the there is power, You must consult the most important article on schedule on autonomy, Schedule 5. 6. Then, my lord, I come to the most important article on schedule on autonomy, Schedule 5. My learned friend rightly points out that Schedule 5, my lord, deals with Assam, Meghalaya, Tripura, and Mizoram. My learned friend rightly points out, excludes them. And then this, my lord, schedule in Schedule 5, my lord, deals with Assam, Meghalaya, Tripura, and Mizoram, excludes them. And then this, now, my lord, we come to the question of autonomy of the Northeast, my lord. My lord, without all these autonomies, my lord, now, my lord, we come to the question of autonomy of the Northeast, my lord. Because unless all this was given, my lord, to the states in question in the light of antecedent discussion, my lord, without all these autonomies, my lord, India would have collapsed by now. This quest for uniformity across the board, because unless all this was given, my lord, 73 to the states in question in the light of antecedent discussion, is not the heart and soul of the Indian Constitution. This quest for uniformity across autonomy, autonomy within federation, seem to countenance special provisions in relation is not the heart and soul of the Indian Constitution. Take that away, my lord. We don't need such a big constitution. It is autonomy, autonomous, and all the antecedent discussions, my lord, special provisions in relation to of these autonomies and special provisions. Take that away, my lord. We can't wish them away, my lord, and say they are just history. And all the antecedent discussions, my lord, become part of these autonomies and special provisions. We can't wish them away, my lord, and say they are just history. Okay. So far, so good. Now, my lord, kindly come to Schedule 6. Okay. So far, so there is, my lord, apart from the ones that are read in Schedule 5, as my learned friend pointed out, this applies to tribal areas in Assam, Meghalaya, Tripura, and Mizoram. My lord, apart from the ones that are dealt in Schedule 5, as my learned friend pointed out, and this applies to tribal areas in Assam, Meghalaya, Tripura, and Mizoram. And subpara 1 is headed Autonomous Districts and Autonomous Regions. They have an in-between is headed Autonomous Districts and Autonomous Regions and Union Territories. They have an in-between status between panchayats. Now, my lord, under Article 1, Subclause 3, Union Territories. The governor, no doubt, my lord, now, my lord, the advice of his council of ministers, wherever Article we read governor, my lord, 3, it is rarely in his personal capacity. Apart from death, the governor, no doubt, my lord, from which your lordship with the advice of his council, the governor may, by public wherever we read governor, my lord, include any area in any of the parts of the said table, exclude any area in any of the parts of the said table, create a new autonomous. The governor may, by public increase the area of any autonomous include any area, diminish the area in any of the parts of the said table, unite two exclude any area in any of the parts of the said table, so as to form create a new autonomous district, alter the name of any autonomous district, define the body, diminish the boundaries of any autonomous district, unite two or more autonomous districts or parts thereof, so as to form a autonomous district, alter the name of any autonomous district, Article 3, define the body, boundaries of any autonomous district. And this is where the entire politics of the Northeast, my lord, and the provision, this is a little akin, my lord, relating to the Northeast arise. Gorkhas say we want Gorkha land. Somebody say I want Bodo land. This is where the entire politics of the, all this, my lord, emanates from Schedule 5, and the provisions and the concept of relating to the Northeast arise. Gorkhas say we want Gorkha land. Then, my lord, somebody says I want Bodo land. Para 2 All this, my lord, there shall be a district council for each autonomous district, and the concept consisting of not so many members shall, then, my lord, Archbishop 4 will be nominated by the governor. And then, my lord, there shall be a separate regional council for each area constituting an autonomous consisting of not so many members shall, of which 4 will be nominated by the governor. Each district and regional council shall be a body corporate for each area which is constituted an autonomous region under subpara 2. What is important, my lord? Each also district and regional council shall be a body corporate, which is sealed. Kindly come to paragraph 3. What is important, my lord, is also what do these autonomous councils do? Kindly come powers of the district and regional councils to make laws. Has your lordship got it? Powers of the district and regional councils to make laws. Has your lordship got it? To each of these is given a lawmaking power, with of course some limits, without which we might lose the Northeast. It is this democratization given a lawmaking power, with of course some limits, that has enabled, my lord, us, without which we special concessions where they are necessary. It is this democratization, given the antecedent history, as I've explained in the case of that has enabled, my lord, us, then, my lord, to make special regional councils where they are necessary. District councils and regional councils, given the antecedent history, as I've explained in the case of Sikkim. Then, my lord, there are regional councils, district councils and regional councils to make laws. Now, my lord, there are two interesting provisions, my lord, which your lordships will probably find in the footnote to the sixth schedule. That is an article, my lord, a subpara 3A, my lord, which your lordships will probably find in the footnote to the, wasn't without, my lord, protest and accommodation, the sixth schedule. That is an article, 3A, subpara 3A, probably in the footnote.
Yes.
Additional powers of North, wasn't without Hills Autonomous Accommodation, and Karbi, has your lordship got Anglong Autonomous Council to make laws, probably in the footnote.
Yes.
Additional powers of North, Kachar Hills Autonomous Council, list 152. Anglong Autonomous Council to make laws. And this includes, my lord, subject to the provisions, of course, of list 17 and 52. Interesting part, as my learned friend points out, in 371, 3AB, communication, my lord, is given to the, it says, interesting to the council, to say roads, bridges, ferries, in 371, communication not 3AB, of communication, my lord, is given to the, it says to the council's address to say roads, bridges, ferries, and other means of communication not specified. Now, my lord, come to 3B schedule 7. Your lordships are familiar, my lord, with the borderland, my lord, agitation. I needn't explore that further, although we have material on it. 3B says additional powers of the borderland. Your lordships are familiar, my lord, to make laws. With the borderland, my lord, agitation. I needn't explore and then that list further. What they can make laws, although we have material on it. 3B says additional powers of the borderland territorial council to make laws. And then lists on what they can make laws. Paragraph 4, my lord. I'm almost done, but not with this diversification point, my lord. Now come to paragraph 4, administration of justice in autonomous districts and autonomous regions. I'm almost done, but not with this diversification point, my lord. Now come to paragraph 4. Administration of justice in autonomous districts, which goes on to then say, may appoint suitable persons to be members of such village councils and presiding officers of such courts. It's a little lower down, my lord. Which goes on to then say, may appoint suitable persons to be members of such village councils and presiding officers of such courts. It's a little lower down, my lord, in that paragraph.
Which is the next clause?
No,
Para 4, you were saying.
I was taking your lordships to para 4, my lord.
That's the administration of justice.
That's the administration of justice.
Which is the next clause?
No,
Para 4, you were
of course, I was taking your lordships to para 4, my lord.
saying. That's the administration
Sub para
of
3
justice.
says the High Court shall exercise jurisdiction over the suits and cases to which provisions of sub para 2 of this paragraph
Yes.
apply, as the governor may for time to time specify. Sub para 3 says the High Court shall exercise jurisdiction over the suits and cases
Yes, Doctor.
to which provisions of sub para 2 of this paragraph
Yes.
apply, as the governor may for time to time specify. Even as regards the High Court.
Yes, Doctor.
Then, my lord, 121, para 12 and 12A. Then, my lord, 121, para 12 and 12A. 12A and 12AA, my lord. I want to point out how in the state of Meghalaya and Tripura, my lord, autonomous districts have laws which are subject to what is equivalent to 12A and 12 procedure. AA, my lord. I want to point out how in the state of Meghalaya and Tripura, my lord, autonomous districts have laws which are subject to what is equivalent to the 254 procedure. And your lordships will see in 12A, notwithstanding anything in the Constitution. Likewise, my lord, 12AA, notwithstanding anything in the Constitution. And your lordships will see in 12A, notwithstanding anything in the Constitution. 12B from Mizoram, my lord. Likewise, notwithstanding anything, notwithstanding anything in the Constitution. It limits even the powers of the legislature. Then 12B from Mizoram, my lord, notwithstanding anything in this Constitution. It limits even the powers of the legislature. President's rule, where is it? No, 370s. My lord makes in federalism, there are no dead horses to be flogged. But diversity that is to be treasured.
You are right, it's
Not
possibly
wished
more
away
diverse than the
in
whole
the
of
name
Europe
of
combined
uniformity.
together.
Europe, America, or Sub-Saharan Africa, there are no dead parts of the South Seas. This is, and so is Jammu and Kashmir, my lord, with its history.
You are right,
It has its own
possibly more
diversity.
diverse than the whole of Europe
Diversity is
combined
necessitated. Europe, America, or Sub-Saharan Africa, take parts of the South Seas. This is so. And so is Jammu and Kashmir, my lord, with its history. It has its own asymmetrical diversity. These are in fact multi-symmetrical because of the absence of the merger agreement, my lord. This makes our constitution unlike any other in my submission. I've called these asymmetrical provisions. Simple examples of multi-symmetrical provisions. You will have French in one area and English in the other. This makes our constitution unlike any other language formula. Those are asymmetrical. The Indian constitution is multi-symmetry of Canada. You will have French in one area and English in the other. Or Belgium in case a three-language formula. For its reasons, I'll now come, my lord, the Indian constitution is multi-symmetrical.
Much of it has been argued, so I don't have to
which
take the
JNK
lordship's
is a part
word
of it, my lord.
for its reasons. I'll now come, my lord, straight away to 370.
Point after lunch that
I'm sorry I've taken some time, my lord. Much of it has been
Because as soon as
argued,
your
so I don't
lordship
have to take
asks
the
for a
lordship's
list, as you
word,
asked,
my lord.
Mr. Zafar Shah, your lordship said, you've done with point 6, now what, come
Point
to the
after
other
lunch,
one.
that-
I have a
I'm
list.
sorry I've taken some time, my lord.
Because as
Dr.
soon as your
Daman,
lordship asks for a list, as you
how
asked,
long would you now take after
Mr. Zafar
lunch?
Shah,
So that
your
the
lordship
next
said,
person-
you've done with point 6,
Could we
now what,
cut
come
it,
to the other one.
Possibly
I have a
curtail
list
it to
which
about
will
half
give
an
you
hour
a
after
lordship
lunch.
can.
Half an hour after lunch, can we
Dr.
conclude it?
May not be.
How long would you now take after lunch?
Just give me that,
So
Manoj.
all right, 45
An hour or
minutes.
so.
2:45 we'll could we move on to the next possibly
Usually
curtail it
arrive
to
late,
about
my
half an
lord.
hour
That
after
knocks
lunch.
off 10
Half an
minutes.
hour after lunch. That's why I said 45 minutes. We didn't say
May not be.
2:45.
Just give me that, Manoj.
All right,
We'll
45
be
minutes. 2:45 we'll move on to the
Your
next.
lordship usually arrive late, my lord. That knocks off 10 minutes.
That's why I said 45 minutes. We didn't say 2:45. But we'll be here at 2 o'clock.
Check. Check. Hello, check. 1, 2. Hello, check. 1, 2. Hello, check. 1, 2. Hello, check. 1, 2.
Lordship has not eaten into my time.
Absolutely not. 2:55.
No, my lord, there's Mr. Dinesh Dwivedi's time not eaten into my time.
Absolutely not.
On
2:55.
technical incompetence, as I did on library. Mr. Dinesh Dwivedi's time to be adjusted my time. I'll do my best. Technical incompetence. I'll do my best. As I did on library. But what I've done now, my lord, I've got to be adjusted. Summary at the end, which I'll hand over. I'll do my best, Mr. Zafar I'll do my best. But what I can't resist now, my lord, on the diversity argument. Summary at the end, which I'll hand over, which is not in your lordship's compilation. But what I can't resist, I've made copies on the diversity argument. A passage from TMA Pi, which is not in your lordship's compilation. So I've made copies, may I hand them over? Give to the other side also. Lord, I'll take your lordship straight away to para 157, which is on page 586. Lord, I'll take your lordship straight away to para 157. And just below, which is on page 586. Placetum D. This is the most evocative understanding of the diversity of our constitution. Apart from the two Delhi judgments, this is the most evocative understanding of the diversity of our constitution. Now, just below Placetum Delhi judgments, which went into depth.
Yes.
All the people of India are below Placetum D, and that is why preferential treatment to a special section of society is not frowned upon. All the people of India is a special right conferred on the religious and preferential treatment to a special section of society because of their numerical handicap and to instill in them. Article 30 is a special right conferred on the religious, even though the minorities cannot per se, because of their numerical handicap and to instill in them underprivileged sense of security and confidence. Now, 158, even though the minorities cannot per se be regarded as the 1 billion population of India consisting of 158 ethnic groups, 52 major tribes. The 1 billion population of India consisting of 6,400 castes, main ethnic and subcastes, 18 major languages, and 1,600 minor languages and dialects. 6,400 castes. The essence of secularism can best be depicted 18 major languages, if a relief map of India is made minor languages and dialects, where the aforesaid 1 billion of secularism can best be small pieces of marble. The relief map of India is made in mosaic. Each person, whatever his her language, caste, religion, are the small pieces of marble her individual identity, which has to be preserved. Each person, whatever when pieced together, language, caste, it goes to form a depiction or her individual with the different geographical features of India. These so small pieces of marble, it goes in the form of human beings with the which may be individually be dissimilar to these small pieces of marble when placed together in the form of a systematic manner produce the beautiful which may be individually be dissimilar each piece like a citizen of India when placed together part in a systematic manner the variations of the color as well as the different shades each piece of the same like a citizen of India are the result of these small pieces of different shades variations of the color as well as the different even of the same color. When one small piece of marble is small pieces, the whole map of India would be scarred and colors and the beauty lost. Even just over the page, my lord. When one small piece of marble is removed, the whole map of India would be scarred. Each of the people of India has an important place in the formation of a nation. Each piece has to retain its color. By itself, it may be an
Each of the people of India has an important place in the formation, but placed in a proper manner.
Each piece has
going into the
its
making
colour.
of a full
By
picture.
itself, it may be an
of India in all its different colors and hues.
but placed in
a
a proper
citizen of
manner,
India stands in a
going
similar
into the
position.
making of a full
The
picture
Constitution
of
recognizes
India
the differences
in all its
amongst
different
the people of
colours and
India.
hues. But it gives
A
equal
citizen of India
importance to
stands
each
in a
of them.
similar position.
Their differences
The
notwithstanding.
Constitution
For
recognizes
only
the
then the
differences
can there
people
be
of
a
India.
unified
But
secular
it gives
nation.
equal importance
Recognizing
to each
the
of them,
need for the
their
preservation
differences
and retention
notwithstanding,
of different
for
pieces
only
that
then
go
the
into the making of
can
there
there
be
be
a
a
unified secular
nation.
nation.
The Constitution,
Recognizing
while
the need for
maintaining
the
inter alia
preservation
the
and
basic
retention
principles of
of different
equality,
pieces that go
contain
into the making
adequate
of the
provisions that
nation.
ensure
The
the preservation
Constitution,
of
while
these
maintaining
different
inter
pieces.
alia the basic
I wanted to read
principles
this,
of
my lord. It's a very
equality,
evocative
contain
adequate
passage,
provisions that ensure the preservation of these different pieces. I wanted
No,
to
my
read
lord.
this, my lord. It's a very evocative passage, my lord. Now, my lord,
Yes.
your lordship will be dealing with pieces of marble, my lord. How you deal with it, my lord, will come later.
Yes.
Your lordship
Now,
will
my lord,
be
may
dealing
I
with
invite
pieces
my
of marble,
lords, my lord, to my
How you deal with
submissions.
it, my lord, will come later.
Yes.
Now, my lord,
Which
may
is
I
in
invite
volume
my
1, page
lords, my lord,
195.
to my submissions.
PDF 195.
Yes.
I'm going to go at super speed, my lord.
Which is in volume 1, page 195.
Because there's a guillotine on my
PDF
head. 195. I'm going to go at super speed, my lord. Very sharp one, I might add. Because there's a guillotine on
No,
my
my lord.
head. I'll just take your lordship very quickly. Very sharp one, I might add. Come to the 198,
No, my lord.
page.
I'll just take your
External,
lordship very
your lordship's
quickly.
page.
Skip all that, my lord.
Come to the 198, my lord.
And come to page 200.
The external,
Which
your
is
lordship's
page.
page.
Skip all that,
Which file are you?
and come to page 200. Volume 1.
I'm not able to get.
Which file are you?
Submissions, my lord.
Volume 1.
Of the written submissions, my lord.
Yes. Yes. WC.
Submissions of all land.
Yes. 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 Oh, I see.
Submissions of all land.
I'm sorry, my lord.
190.
Your
Oh, PDF page 195.
I'm sorry, my lord. Page 195.
Where it starts, my lord.
190.
195 to
There is
280.
an index which I
PDF
won't
page
trouble your lordship with, my
195.
lord. Page 195.
volume
Where it
2.
starts.
But I'll take
195 to
volume 1.
280.
There's an
Volume 1.
index
Volume
which
2
I
was
won't
Mr.
trouble
Sybil's
your
submission,
lordship with, my lord.
which came,
my lord, a few days late.
Volume 2.
But I'll take volume 1.
Volume 1.
Volume 2 was Mr. Sybil's submission,
volume 1
which
page.
came, my lord, a few days late.
Article of Convention.
200 पे नहीं आ रहा है, वो 00 पे आ जाता है। नहीं, volume 1 पे है।
But at 200. Your lordships have it, my lord?
Yes.
But at 200.
Yes.
Your lordships have it, my lord?
I'm taking your lordship's
Yes.
on PDF 200.
Yes.
In para 1.5. I'm taking your lordship's
Because all the other documents have
On
been
PDF
read, I'm
2.
not going to repeat them. The history has been shown to your lordships.
in para
But
1.5.
I made a point, my lord, because all the other
About
documents
why
have been read, I'm not going to
the
repeat
merger
them.
agreement
The
was
history has
important.
been shown to your lordships. And why
But
370
I made a
in one
point,
sense,
my lord,
represents
about why
the standstill and
the
merger,
merger
agreement was important.
I'm going to read this
And
passage,
why
my lord,
370 in one sense
from
represents the
Premnath
standstill
Kaur.
and merger agreement in para 1.5.
I'm going to read this
Your lordship
passage, my lord,
Yes.
from Premnath Kaur,
In para 1.5.
referring to the
Your
past, my
lordship
lord.
Yes.
Thus, there can be no doubt that this act of 1939 marked the second step taken by the Highness. Thus, there can be no doubt that this act, the administration of the state, it did not constitute even a partial surrender of taken by the Highness of his sovereign rights in favor of the administration of the state.
Even
it did
after
not
the
constitute
instrument of
even a
accession,
partial
my lord,
surrender of
he
his
had not
Highness
given up his
of his
rights.
sovereign rights in favor of the produce of that. Your lordship will come
Even
over the
after
page.
the instrument of accession, my lord,
he had not given up his rights. I can get the PDF numbers to this if your lordship wants. That your lordship will come over the
No, we
page.
got it.
Now, my lord, dealing with the PDF numbers to this after the instrument of accession.
How many judges was Premnath called?
Now, my lord, dealing with after the instrument of accession.
How many judges was Premnath called?
No, it's yes, 5 judges.
Right.
These are all constitution benches. Now, my lord, may I take your lordships to 1.7? These are all constitution benches. Now, my lord, may I take your lordships to 1.7?
This is in relationship, in regard to the relationship of the Maharaja with the Praja Sabha. This is in relationship.
I'm now building
in
on
regard
that.
to the relationship
Yes. Therefore, my lord, what
the Maharaja with the Praja Sabha.
Represents, this is two powerful democratic movements, my lord.
Yes.
One in the people of India, my lord, and the other, my lord, in the people of Kashmir. Is two demanding of their democratic movement, which is eventually what he did. One in the people of India, Raj Sabha, and the other, National Assembly, the people of Kashmir. He didn't agree to a constituent assembly, which is eventually what he did. He gave a Raj Sabha, no, my lord, 1.7 National Assembly, but he didn't agree to a constituent assembly, which continued to be the absolute monarch of the state. 1.7. And in the eyes of international law, he might conceivably have claimed the status continued to be the absolute monarch of the state. And in the eyes of international law, he might conceivably have claimed the status of a sovereign and independent state. Said externally, all the instrument of accession did between external sovereignty and internal sovereignty. And said externally, that's why I made the distinction between external sovereignty and internal sovereignty. I'm coming not to the instrument of accession, not in 1.8.
That's 1.9. Not with.
That's right, my lord, that's the instrument of accession. Immediately after that comes 1.8.
That's 1.9.
That's right, my lord, that's the instrument of accession. Immediately after that comes 1.8. The Maharaja took the very important step of recognizing the fact that his state was a part of the by the instrument of accession. That's all that the took the very important step of recognizing the fact we that can't say at that point that he had surrendered all his sovereignty. That's all that the instrument process began partly politically because of the political movement. At that point that he had partly because of 370, my lord. That process began partly politically because of the political movement coming together, and partly because of 370. The governor, the president, all that comes together. That's where we see because there was no merger or standstill agreement. Assembly, the governor, the president, all that comes together because there was no merger or standstill agreement. The Maharaja, my lord. Now I won't read, my lord, 1948 of where he talks of his Maharaja ministers of 1948. I'll just come straight away, my lord, to where he talks of his council of ministers. Sardar Patel said over the page in 1.13. I'll just come straight away, my lord, to what Sardar Patel said over the page in 1.13. In view of the special problems with which the government of Kashmir is faced, we have made a special provision for the continuance of the in view of the constitutional relationship the government of Kashmir on the existing basis. We have made a special provision for the continuance of the and it's very important to understand what 370 really represented and what the instrument of accession really did. And it's very important to understand what 370 really represented. The rest of the process of and what the instrument of accession really did. Adjustments. Of sharing of power. It bound itself never done in India. The rest of the process of democratization. Even in the white paper, of adjustments of sharing of paragraph, it says we are not dealing with Jammu and Kashmir. Even in the white paper, my lord, on the states, there is one paragraph it says we are not dealing with Jammu and Kashmir. Then, my lord, your lordships will just come to 1.21. Then, my lord, your lordships will just come to 1.21. On the 12th of November, pursuant to a resolution of the Constituent Assembly resolving to end hereditary rulership on the 12th of November, Yuvraj Karan Singh was elected to the post of so and dynastic rule in J&K hereditary rulership in the state.
Now, your lordships have
Yuvraj
already
Karan Singh was
been
elected
shown
to the post of
how
and dynastic rule in J&K emanated from the
Now, your lordships
Assembly
have
of
already
Jammu and
been
Kashmir
shown
Constituent Assembly
how
and became part of our
48
constitution. Emanated
This
from
part, my lord,
the
your lordships,
Assembly
I
of
I
Jammu
needn't
and
give you
Kashmir
cross
Constituent
references
Assembly and became part of our constitution.
This
No, my
part,
lord,
your
I'll
lordships,
skip the rest.
I needn't give you cross references.
1 point.
Need I, my lord?
2.4, my lord, I've already read. No, my
The
lord,
second proviso
I'll
to
skip
Article
the rest.
3.
Yes, we
So I won't read it again, my
1
lord.
point. But 2.4, my lord, I've already read. I come, my
The
lord,
second
to
proviso
page
to Article 3.
Yes, we
So I won't read it again, my
11,
lord.
1.30. I come, my lord, to page 11, 1.30.
Before that, my lord, just
Dr. Dhawan, just
1.25.
one thing, just more for your juniors than for you. The dates which you have given in the written
Before that, my
submissions,
lord, just
Dr. Dhawan, one
1.25.
thing is missing in Mr. Sibal's list of dates. The dates which you have given in the if you have it in one place. If likewise, when the respondents begin, in Mr. Sibal's list of dates, we have one consolidated list of dates, so that we don't have to have it in one place. Likewise, when the respondents begin, 2 or 3 different. It would be very nice if we have one consolidated list of dates, so that we don't have to sort of then and something which you're adding, because I think we were reading Mr. Sibal's list of dates. There's no innuendo in any of them. It's just state the date. So and something which you're adding, because I think we were reading Mr. Sibal's list of dates. There's no innuendo in any of them. It's easier for us state the date. So if you feel that there's something missed out, then you can make that changes in that list of dates. So it'll be a little easier for us. All right, fair enough.
This is what I'm trying to do.
Fair enough. Then there's not.
Not just reading it as a list of dates.
Fair.
Now, 1.25
to the list of
All right,
dates.
fair
This is
enough.
what I'm trying to
Fair
do.
enough. Then there's not.
Not just reading it as a list of dates.
Fair.
Now, 1.25, my lord, on the 17th of October 1956, the Constitution of Jammu and Kashmir was adopted by the JK. 1.25, my lord, on the 17th of October 1956,
Yes.
the Constitution of Jammu
Now, my
and
lord,
Kashmir was
this
adopted by the JK.
particular aspect of Indian federalism,
All the details are
to
given there, my
have
lord.
a separate constitution for
Now,
a
my lord,
state. This
for others you
particular
gave
aspect
autonomous
of Indian
regions,
federalism,
you
to have
them
a
together,
separate
you expanded
constitution
it.
for a state. But this
For others, you gave autonomous
and the
regions.
JK constitution bond them
Of
together.
1957, be wished away.
But this, by an amendment
Can
to
the JK Constitution
272,
of
273 and Article 3,
1957 be wished away?
it simply can't, my lord. By an amendment to, so one of the big losses is, whereas it
273 and Article
it's like
3.
Macbeth, the Thane of Fife, he had a wife,
It simply
where is she
can't,
now?
my lord.
JK had a
So
constitution,
one of the big
where
losses
is it
is,
now? Where has it? It's
has
like
it been
Macbeth,
subsumed
the Thane of Fife, he had a
by
wife, where is she
273?
now? JK had a constitution, where is it now? And when I go to 273,
Has it been
my lord, I'll
subsumed?
deal with that. By 273.
Now, my lord, I come to asymmetrical federalism at 1.30.
And I've
Kindly change that to
multi-symmetrical, as I've argued.
Now, my lord, I come to asymmetrical federalism at 1.30.
Kindly change that to multi-symmetrical, as I've argued.
Now, my lord, all those references are there.
But, and of course, I've given your lordship a list.
Now, my lord, all those references are there.
Which is not repeated here. But,
So I'll come straight away to 1.33.
and of course, I've given your lordship
The
a
importance
list,
of the Delhi decision.
which I don't want, which
I'll
is
take
not
up the
repeated
second
here.
decision
first.
So I'll come straight away to 1.33. The Chief
importance
Justice,
of the
after
Delhi
reviewing
decision.
the asymmetrical provision
I'll take up the
described
second
above
decision
in
first.
State of Delhi so-and-so in 2023, held
The
that
Chief
regard
Justice,
must
after
be
reviewing
had to
the
the principles of asymmetrical federalism
in State of Delhi
embodied in the
so-and-so
Indian
in
Constitution
2023,
and that constitutional
held that regard
principle
must be had to the
substantive
principles of
asymmetrical
to this
federalism
underlying principle.
embodied
I'll
in
read
the
that
Indian
paragraph.
Constitution,
Actually, I should read it
and
at
that
the end, but I'll
constitutional
read it now.
principle must be given
This
substantive
variance
in the
this
constitutional
underlying
treatment of union
I'll
territories,
read that paragraph.
as
Actually, I
well
should
as the
read it at
absence
the
of
end,
a
but I'll
homogeneous
read it
class,
now.
is not unique.
This
variance in the
union
constitutional treatment
The
of union
Constitution is
territories,
replete with
as well as
instances
the absence
of
of
special
homogeneous
arrangements
class,
being made
is
to
not
accommodate
unique the
only to
specific
union
regional
territories.
needs of states.
The Constitution
in
is
specific
replete with
areas.
instances
Therefore,
of
special
NCT
arrangements being
is not
made
the first
to
territory
accommodate the
which has
specific
received
regional
special
needs
treatment
of states
through a constitutional
in specific
provision.
areas.
But it is another
Therefore,
example in
NCT
line with the
is not
practice
the
of the
first territory
Constitution, which
has
has
received
received
arrangements
arrangements
which treat federal units differently. But it is another example in line with the practice of the Constitution. For instance, visiting arrangements of the Constitution, which treat federal units contain special provisions from each other areas to account for various states, as well as the entirety of Article 371. The marginal notes to these contain special provisions of 371 of various states, and over the entirety of some states where arrangements, marginal notes in the nature of asymmetrical rubric of federalism 371 are made in the spirit of accommodating the difference and specific requirements of regions in the nature of asymmetrical. The next line are made in the 41 of accommodating your lordships to the PDF specific requirements of regions. Enough of what I want to refer to. The next design of our Constitution is such, I'm not taking your lordships to the PDF, the interests of different regions. Enough of what I want to refer to. Providing a larger design of our Constitution is such and union that it accommodates the interests of different local aspirations while providing a larger constitutional unity and diversity different is not only union territories. Common preserves the local also embedded in our constitutional structure. Unity and diversity is not only used in the Constitution. Common parlance gives substantive weight embedded in our constitutional structure. This is the interpretation of the how we approach the Constitution that has been done otherwise. Weight to the underlying principles. This is my lord. I add to this how we approach the Constitution that has been done otherwise also. Huge number of precedents, my lord, of what is called transformative constitution. I add to this, my lord, the huge number of precedents, my lord, of what is called transformative constitutionalism. 1.36. The ultimate goal, that's from Navtej Singh Johar, of our magnificent Constitution is to make right the upheaval which existed, the ultimate in Indian society before the adopting of the Constitution. Of our magnificent Constitution is to make that the Indian Constitution is a great social in Indian society, almost revolutionary in its aim of transforming a medieval hierarchy that the Indian Constitution is a modern egalitarian democracy, almost and its revolution can only be comprehended in its aim of transforming only by a spacious social science society, not into a modern egalitarian democracy, traditional legalism. And its provisions, the whole idea of having a constitution is to only by a spacious social science splendid, not a pedantic. Therefore, the purpose of having a constitution is to transform the whole idea of having a constitution for the better, and this objective is for the fundamental pillar. Therefore, the purpose of having a constitution is to transform this. Then, my lord, for the better, the Chief Justice, and this objective was, my lord, fundamental in the 290 of transformation constitution of the Delhi decision. Then, my lord, the constitution is a transformative document, my lord. The realization of this transformative potential rests ultimately in the ability to breathe life and meaning into its abstract concepts. The realization of the Constitution was not intended, rests ultimately in the ability to breathe life and meaning into its abstract concepts. Draft persons to be a significant instrument of bringing about social change by its caste-based feudal society was intended by centuries of oppression and discrimination to be a significant instrument of bringing about social change. As our constitutional jurisprudence witnessed by centuries of oppression, the realization of the transformative potential of the Constitution has our constitutional jurisprudence equality away from its evolved, the realization of the transformative potential of the Constitution. Well, I cite this for a reason, evolution of equality away from when this hearing began, to its it appeared to me that we were reading the Constitution as a reason. For a long time, my lord, we were going to this word began word and this proviso. It appeared to me that we were reading that is not how constitutions were meant to be read or to be transformed. For a long time, my lord, we were going to this word and if your lordship will come to this proviso, my lord. Question 1.41, I won't read it, were meant to be read or to be transformed. Morality is also mentioned. Then, my lord, in various judgments will come to this. My lord, the Chief Justice, when you refer to Pratap Bhanu Mehta's contribution, etc. also mentioned, my lord. Now, my lord, straight of NCT versus Union of India. My lord, the Chief Justice, if the moral values of our Constitution were not upheld, every state, now, my lord, straight of NCT versus Union of India may not be enough. If the moral values of our Constitution were not held, in order to truly understand every state, the text of the Constitution may not answer to protect necessary to answer value. What is that Constitution trying to say and to identify the broadest possible range to fix the meaning of necessary to answer what is that constitutional morality does not mean allegiance, and to identify the broadest provisions and principles of the Constitution to fix the meaning of it signifies a constitutional culture. Constitutional morality each individual in a democracy must have the substantive provisions and identifies certain provisions. It signifies a constitutional culture. Chief among each individual in liberal values which govern the making of India's constitution and created expectations from the constitutional one of the essential features being liberal values which govern the making of India's constitution. Thus is the ability and commitment to arrive at decisions on one of the essential features of constitutional morality. Thus is the ability and commitment to arrive at decisions on important. It's going to be my submission, my Lord, that this deliberative exercise, despite all differences, has not taken place with the changes of the J&K. It's going to be my submission, my Lord, that this deliberative exercise had a number of questions that were asked in Parliament till the last changes of the J&K. Your Lordship has seen that. Are you changing 370? The answer was no. And suddenly, my Lord, out of the blue, till the last day, entered into fourth office. Your Lordship has seen that. Are you changing 370? The answer was no. Consultation and suddenly, my Lord, out of the blue, fundamental. We entered into fourth office. To the manner in which we read constitutions, my Lord, and how each provision comes into place. Consultation of concurrence, my Lord, is fundamental to the manner in which we read constitutions and how each provision comes into place. Just read, my Lord, the NCT decision. Then, my Lord, that's the earlier one, my Lord. While interpreting the provisions of the Constitution, Lord, the safe and most sound approach for the Constitutional Court to adopt is to read the earlier one, the Constitution, and while interpreting the provisions of the Constitution, so that the quintessential democratic sound approach nature of our Constitution and the paradigm of read the words of the Constitution and the by way of citizenry engagement, so that the quintessential democratic court must nature of our Constitution and the paradigm of represented glorifies the by way of citizenry engagement are not a Constitution has mandated a federal balance, adopting interpretation which glorifies the democratic is a short to the state of the Constitution. As opposed to centralism, mandated a balanced federal structure mandates the independence of certain union does not usurp all the power of the state government. As opposed to centralism, the states enjoy freedom federal structure mandates solicited interference from the central union does not usurp all the matters while exclusively falling into the domain. And so this is the approach, my Lord, without towards Constitution to multi-symmetric with respect to matters while exclusively falling. I will take your Lordship. So this is the approach, my Lord, towards Constitution to multi-symmetric federalism. Now, my Lord, I will take your Lordship straight away, my Lord, to 370. I think at some stage a question fell from your Lordships. Weren't any protests made before that, my Lord? I just want to take your Lordships to 2.15. I think at some page 221 fell from your Lordships. Weren't any protests? There is a literature that could fill I just want to take your Lordships to 2.15 over 3 at page 221 external. And then, my Lord, the state, my Lord, there is a literature Autonomy that could fill a library. Read this out on the protests over 370. And then, my Lord, the state, and of course it goes Autonomy Committee further extreme, my Lord. Read this but this is, my Lord, the constitutional understanding, which is not too dissimilar with other federations. And of course it goes, I won't read it, my Lord, further extreme, my Lord. But this is, my Lord, the constitutional understanding, which is not too dissimilar. Once again, my Lord, I've reproduced here the debates. I just pointed it out to your Lordships. I'm not going to read those out, my Lord. Iyengar's speech has been read out to your Lordships, my Lord. Once again, my Lord, 2 or 3 times. I've reproduced here the debates. It's just that on page 224, whatever I've highlighted out to your Lordships, my Lord. Again, the government of India have committed themselves to the people of Kashmir in certain. It's just that on page 224, they've committed themselves to the position that an opportunity would be given to the people of the state. Again, the government to decide for themselves whether they will remain with the republic or to wish to go out of it. They've committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the republic and the impartiality of the president. We are also committed to ascertaining the guarantee. We have also agreed with the will of the people through the instrument of the Constituent Assembly and the impartiality of the Constitution of the state plebiscite will be guaranteed. We have also agreed that the will of the people jurisdiction through the instrument of the Constituent Assembly. This is the commitment, my lord, will determine the Constitution of the state as well as the sphere of union jurisdiction. Then, my lord, at the bottom of the page, till a constituent
This is the
assembly comes into
commitment,
being,
my lord,
only an
that lies
interim
behind
arrangement is
Article
possible,
370.
not arrangement which could at once be brought in line with the arrangements that exist.
Then, my lord, at the
with other
bottom of the
states.
page, till a constituent
Now,
assembly
if you
comes
remember
into
the
being,
viewpoints
only
I've
an
mentioned,
interim
it's an
arrangement is
inevitable
possible,
conclusion, not arrangement which could at once be brought in line with the arrangements that exist with other states.
is an attempt to establish.
Now, if you
such a
remember the
system.
viewpoints I've mentioned,
Then,
it's
my
an
lord, I
inevitable
will
conclusion that at the present we
skip,
could
my
establish
lord,
an interim
other
system
passages that have been
is
read
an
out
attempt to
in what you have
establish
listed.
such a system.
Then, my lord, I will skip, my lord, other passages that have been read out, my lord, to your lordships. The JK Constituent Assembly, my lord, 11.21. I'm coming to
JK
page
Constituent
external
Assembly,
page
my lord,
11.21. Sorry, 217. I'm coming to page external page 217. Sorry, 217. 227. Why is it? Sheikh Abdullah's speech has been read, but this is their understanding in the absence of a merger agreement. As I indicated earlier, the 370 has been read, nature, but this is their establishing the relationships in the absence of a merger portion agreement. That I've highlighted. This arrangement involved a division of sovereignty, which is the normal feature of establishing the relationship beyond the powers transferred. And in that portion that I've highlighted, dominion, this arrangement involved a division of sovereignty, which is the normal feature of federation. Sovereignty, beyond which is what is reflected in the JK Constitution. By it to the dominion, the state enjoyed complete. So, my lord, the instrument of accession says list 1, list 3, which is what is reflected in the JK Constitution. We have all the residuary powers. Therefore, control over the. So, my lord, the instrument of accession says list 1, list 3. They have their place, but we have all the residuary powers. Therefore, control over the state lists, my lord, as far as they are concerned. When the draft constitution, my lord, was introduced, I'm coming to, my lord, 11.25 at 231 and 232. When the draft constitution, my lord, was introduced, I'm coming to, my lord, 11.25 at 231 and 2, just at 232, my lord, just above 11.26. By this I mean that all these special constitutional privileges
which are state enjoyed prior to 1953
just above 11.26.
are enjoyed
By this I
mean even
all
today.
these special
in other words, the
constitutional
state
privileges
enjoys
which
the
are
same
state
kind of
enjoyed
autonomy
prior to
which
1953
stood prior
are
to
enjoyed by her
1953. Even today.
Therefore,
In
to
other
say
words,
the instrument
state
of
amount
accession
enjoys
wipes
the
things
same
out,
kind
my
of
lord, is
autonomy
simply not correct.
which it stood prior to 1953.
Now, my lord, 11.28,
Therefore, to
I've
say the
already read
instrument
out to
of
your
accession
lordships, my lord,
wipe things out, my lord, is simply not correct. Because it imposes a limit. One question that was put,
now,
can
my lord,
370 be amended or
11.28,
not
I've already
amended?
read it out to your lordships, my lord.
Is it there permanently?
Because it
Mr.
imposes
Sabal
a
said
limit.
that's not before your
One
lordship,
question
but at
that was
any
put,
rate,
can
it may not
370
have
be
been a
amended or
sufficient
not
answer.
amended?
There is a proviso, my lord, that was added
there
by
permanently.
CO48.
Mr. Sabal
CO48
said that's not before your lordship,
foundational
but at any
document,
rate,
my lord. It may not have been a sufficient
and that is
answer.
at 11.2.
There is a proviso, my
provided
lord,
further that
no
was
such
added by
amendment shall
CO48
have the effect in
CO48
relation
is
to
a
the state of
foundational
Jammu and
document,
Kashmir
my lord.
unless applied
And
by
that is
the
at
order of the
11.28,
president under
provided
clause
further
1
that
of
no such
370.
amendment shall have the effect
In other
in
words,
relation to
after
the
you go
state of
through the
Jammu and
amendment
Kashmir,
process, unless applied by the order of the president under clause 1 of 370. In other words, after you go through the amendment process, now, my lords, can this proviso,
Somebody's cell phone triggered.
what has happened is, my lord, when the microphone was on, some things emerged there which I didn't want this to emerge because I was talking to my colleagues. What has happened is, my lord, when the microphone was
That's what I
on,
went to
some
him and
things
told him
emerged
that
there
your
which I didn't
whispers
want
are also
to emerge
being
because I was
recorded.
talking to my colleagues. I hope they will be excised.
Lord, we will deal
That's
with
what
all
I
that.
went to him and told him that
With a
your
pinch of
whispers
salt,
are
my lord.
also being recorded.
My lord,
But it's quite
we will deal
accurate,
with
huh?
all that, my lord.
शाम को बोलो निकालने.
With a pinch of salt, my lord. I shudder to think, my lord,
But it's
if
quite
this was
accurate,
the
huh?
case when we were arguing Babri Masjid, what would come in the transcript? Such a huge amount of exchange took place. I shudder to think, my lord, if this was
Now, my
the
lord,
case when we were arguing
therefore,
Babri
my lord,
Masjid, what would
how
come
do
in
you
the
amend it
transcript?
370?
Such a huge amount of exchange.
You
took
amend
place,
it
my
through
lord.
the 368 process. Now, my lord,
But there was,
therefore, my
in
lord,
CO48,
how do you
my
amend
lord,
the
a provision
370?
that
You amend it
you will
through the
then go to
368
370
process.
and follow the procedure in
But there
370.
was,
In CO 48, and that's very important provision. Your Lordship asked that what was lost on the 4th of August. You will then go to 370 and follow the procedure. And they didn't even use the amendment power. And that's very important, my Lord. Your Lordship asked what was lost, which is the only power available to them. This is something that was lost. And they didn't even use the amendment power. Not the circuitous process that they used in 272 and 273. Which is the only power available to them, my Lord, to delete 370. Not the circuitous process that they used in 272 and 273.
Yes, Dr. Sir.
Now, my lords, on 235.11.32 onwards. My lord, your lordship conferred, that took time as well.
Yes, Dr. Sir.
Now, my lords, happy though I am that your lordship 11.32 onwards. My lord, I'm going to be my lord, your lordship conferred, that took time as well. Now, my lord, here are all the cases. Happy though your lordship I am that needs to go through Premnath's call, which I've summarized. My lord, I'm going to be super 11 points. Just give me that indulgence. Because it actually explains my lord, here are all the cases was after 1950. Your lordship needs to go through Premnath's call, which I've summarized. When there was an instrument of accession, but no merger agreement. Because it actually explains what the situation was after 1950. When there was an instrument of accession, but no merger agreement. On page 236, my lord, my submission, my lord, from Premnath Call, page is application of 370 of the Constitution to the state of JK also does not impact the plenary powers of the Maharaja. From Premnath Call, the form of the Constitution to application of 370 of the matter left to be determined by the JK also does not impact the plenary powers of the Maharaja. The constitutional relationship between the Union and the states was governed by the terms of determined by the State Constituent Assembly. So the internal relationship was taking the constitutional relationship between the Union and the states was governed by the terms of the IUA. So the internal relationship, had to still be determined. An argument has been made on the basis of Puran, Lakhampal, etc. What is the meaning of modification? And they say it's very wide. No, my lord, but, my lord, your lordship has to read it in context. An argument has been made, and that is when the matter was not referred, etc. What is the meaning of modification? And they say it's very wide. 7-judge bench, but my lord, your lordship has to read it in context. Please read these decisions when the matter was not referred. Don't read them outside the context. To the 7-judge bench, my lord, your lordships took the view that please read these decisions. No, my lord, I'll come to context. 17, don't read them outside the context. What I've done in the meanwhile, my lord, is done a short page. No, my lord, I'll come to 3, my lord. 17, my lord. But I'm not giving it now because your lordship may introduce the guillotine. What I've done in the meanwhile, my lord, is done a short page. No, my lord, kindly come to 370. But I'm not giving it now because your lordship may introduce the guillotine earlier.
Does that begin at
no, my lord, kindly come to 370. Sorry, my lord.
Is that? Oh, sorry. I thought you were referring to your submissions.
My lord, I'm not going to repeat what's in the submission. I'm going to just, my lord, stress what is not in the submission, which I've stressed orally.
Oh, sorry. I thought you were referring to your submissions.
My lord, I'm not going to repeat what's in the submission.
Yes, sir.
I'm going to, no, my lord, we need not be troubled. What is not in the submission, which I've stressed orally.
Fair.
That has been the great, my lord, call. This is a temporary provision.
Yes, sir.
It's temporary, no, my lord, we need not be troubled. That 370 indicates at all. Therefore, my lord, has been the great, in my personal view, my lord, this is a temporary provision. It's temporary to the extent 3, which deal with the Constituent Assembly, my lord. Therefore, my lord, in my personal view, my lord, 370 subclause they have invoked this, and 3, which deal with the Constituent Assembly, my lord. All of a sudden, a provision, my lord, which is constitutionally beyond the extension of the Assembly, they have invoked this, has suddenly been used in CO273. All of a sudden, a provision, my lord, which is constitutionally beyond CO273, the extension of the Assembly, and has suddenly been used. Is CO44, is it? 44 is the only time, my lord, CO273, 370 subclause 3 was used. I think it's in 1952, CO44, and now, my lord, in the year 2044 is the only time, my lord, So, my lord, what
370
remains,
sub clause
my lord,
3 was used.
after the
In
Constituent
1952,
Assembly?
and now, my lord,
In our
in the year
submission, what
2019.
remains is 370.
So, my lord,
Subclause
what
1.
remains, my lord,
After the Constituent Assembly.
not to be read
In
as
our
a statute,
submission, what remains is 370,
but to be read in
context.
And what are the provisions here, my lord? Not to be read as a statute. I'm not going to read them out, it's been read ad nauseam, my lord.
To be read in context.
It says, follow the instrument.
And what
of
are the
succession-
provisions
here, my lord?
Accession, my lord.
As far as
consultation is
read
concerned.
ad nauseam, my lord.
For the rest, there must be concurrence.
It says, follow the instrument of
Succession, accession, my lord.
as far as
Consultation is concerned. And the
For the
same is
rest,
true,
there
my
must
lord,
be
of D.
concurrence. 371D.
Those provisions, my lord, are governed by the two provisions.
And the same is true, my lord, of D. 371D.
which then talk of
Those
consultation
provisions, my
and
lord,
concurrence again, are governed by
The reason
the
why
two
I said, my
provisions.
lord, that 370 could not be tinkered with during President's rule is because
Which
there is a
then talk of
mandatory
consultation
requirement
and
as there
concurrence
was in
again.
Article 3. The reason why I said, my lord, that 370 could not be tinkered with during President's rule is because there is a mandatory
consultation
requirement as there
and
was in
concurrence.
Article 3. You can't say we wiped out the Constitution, we wiped out all the treaties, so that 370 is gone.
About
Amend it.
consultation
Go through
and
that particular
concurrence.
process. You can't say we wiped
But
out
by
the
the circuitous
Constitution, we
route,
wiped
my
out
lord,
all the treaties.
mandatory
So that
provisions
370
which
is gone.
survive in 370
Amend it.
subclause
Go
1
through that particular
are
process.
violated. And they can't be done under
But by
President's
the
rule for a very
circuitous
simple
route, my
reason.
lord, because
Mandatory
it says
provisions
which survive in
the
370
state government
subclause 1 are violated.
Consultation with the
And they
government
can't
of
be
the
done
state
under
is declared by
President's
the
rule for a
President
very
to
simple
correspond in
reason.
such matters.
Because
Other
it
matters
says
in such a list with the concurrence
state
of the government
government,
of the
my lord.
state.
Consultation
Consultation
with
one
the
in this
government of
article
the
shall
state
apply
is
in
declared
relation
by
to
the
the
president
state
to correspond in such
And
matters.
then, my lord, once
Other
again,
matters
in such a list
Now,
with
my
the
lord, can we
concurrence
wish
of the
this
government of
away
the state.
by some circuitous route?
Of course, provision 1 in this article shall apply in
370,
relation to the
by
state.
far from being a relic,
And then, my lord, once again, in
is in fact what
Now,
is
my lord,
there
can
in the
we wish
merger
this
of
away
agreement by some
read?
circuitous route with the instrument of accession. 370,
By
in fact,
far
my lord,
from
I
being a
say
relic, my
this
lord,
is part is in fact and what is
parcel,
there in the merger
my
of
lord,
agreement
of the
read multiple federalism that exists with the instrument of accession. You can't use
fact,
these
my lord,
provisions,
I
my
say
lord,
this
without
is part
subjecting them to the discipline
and parcel
of Article
my lord,
370.
of the
Multiple federalism that
And that's what
exists.
Damnu, my lord. Damnu,
You
if
can't
your lordship
use
will
these
get the-
provisions, my lord, without
Also says
subjecting
you can't
them
do
to
it.
the discipline of Article 370. So, my lord, I asked, come back
And
to
that's
my
what
broader
Damnu, my lord,
proposition that
Damnu,
while
if your lordship
President's
will get the-
rule was in operation,
Also says you can't
could
do it.
not use Article 3 because you can't substitute
So, my
one
lord, I asked,
legislature for
come
another.
back to my broader
And you
proposition
can't, my lord, do away
that
with
while
370
President's rule
for a very simple
was in
reason
operation,
that
mandatory
you could not
provisions
use
of the
Article 3
Constitution do
because you
not
can't
say
substitute like
that
one
Parliament
legislature
can
for
do
another.
this and the
And
President
you
can
can't,
do this.
my lord, do away
It
with
says
370.
it must
for a
be
very
done
simple
by the
reason
government
that mandatory
of
provisions
JK,
of the
which is
Constitution
not, my
do
lord,
not
say
the Erzatz
that
government
Parliament
of JK,
can do this
but
and the President
in
can do this.
272, it says
it must
with
be
the
done by
Council
the
of Ministers
government
of JK,
and
which
that
is
is
not
fundamental
my lord,
to
the
the
Erzatz
operation
government
of any
JK,
government.
But in
So,
272,
you don't do it with the
it says with the Council of Ministers.
Council of Ministers. Can you do
And
it
that is
simply?
fundamental to
Lord,
the
the way
operation
it was
of any
introduced
government.
in Parliament by Mr.
So
Amit
you
Shah.
don't do it with the
You simply do it by saying we're using 370
Council
and
of
this is how it's
Ministers.
done. Can you do it simply
In
not the
President's
way
rule, my
it
lord,
was
it
introduced
cannot
in
be
Parliament
done.
by Mr.
There is
Amit
no
Shah?
tearing hurry, my lord, in
You
our
simply do it by
Constitution to
saying
say
we're using 370 and this is how it's done.
that the amendment power in President's
Can be
rule,
used
my lord,
and abused
it
whenever
cannot
you
be
want
done.
it to.
There is no tearing hurry, my lord, in our Constitution to say that the amendment power
Oh, show me a deal.
can be used and abused whenever you
Lord, I
want
want
it
to
to.
show quickly two decisions, my lord.
On why the merger is separated from.
It is in volume 6, my lord, of the cases. And the
Lord, I want
case
to
is
show
Pramod
quickly two
Chandra Dey.
decisions, my lord, on why the
It's at
merger is
page
separated from.
1587. It is in volume 6, my lord, of the cases.
PDF.
And the case is Pramod Chandra Dey. It's at page 1587. And I want PDF 144. PDF. And I want PDF 144. The steps that were required. And I'm saying that this, in fact, is in a sense, my lord, the merger agreement steps that were required. And I'm saying that this, in fact, no, my lords, I take your lordship in a sense, 1596. The merger agreement is really what 370 is. Sorry, my lord. Volume 6. Case is volume 6. I take your lordship's item number 10, page 1587.
Dr. Dhawan, which volume?
Sorry, my lord. It starts at 135. And I'm taking your lordship to 1596. Item number 10 at 1587. PDF. It starts at 135. And I'm taking your lordship to 1596. My lord, at 144. This is in para 10. On page 1596, my lord. The bottom of the page, my lord. This was, my lord,
PDF page will that
this is in para 10. On page 1596, my lord. The bottom of the page, my lord. This was, my lord, some.
PDF page will that be?
It says of the instrument of accession. In the last 5 lines of page 1596, it says of the instrument of accession. This accession, that is, instrument of accession, in the last did not affect the continuance of sovereignty of the rulers entering into the agreement, save as provided by or under this accession, that is, instrument of accession. So there was no did not affect the continuance of sovereignty of the rulers internal sovereignty entering into the agreement, save as provided by. And then, my lord, going over the page. So there was 97. External sovereignty was 4 lines from the top. But the internal sovereignty was the signing of what has been termed the standstill agreement. And then, my lord, going over the page appears in the white paper at 1597, my lord. 4 lines from the top. The second step was the signing of what has been termed the standstill agreement. The form of the acceding state signed the standstill agreement which provided for the continuance in time of all subsisting agreements and administrative arrangements, and a few in the matters of common concern between the acceding states signed the standstill agreement. The first phase of the continuance in time of all the Indian states into the Indian dominion was the accession between the states. The second phase. The first on the merger of the states into the dominion of the Indian states into the Indian the merger dominion was the accession of the states. Now there was no merger agreement. The second phase followed on the merger of the states. Where was the merger agreement of India as a result of the merger sovereignty? It was said, my lord, in Premnath, there was no merger agreement. Or we say that this is the essential step. So where was the merger agreement? Internal sovereignty. Either we continue the sovereignty it was worked out. My lord, in Premnath call. Or we say that this is the essential step. Then it says, my lord, a little further down, my lord, internal sovereignty and internal arrangements are worked out. But 4 lines below that, says, my lord, as a result of the merger agreement signed by the rulers of these states on or after 14th December, but before the 1st of January 48, the dominion of India was vested with sovereign powers. As a result of the merger agreement left only with their private property on or after 14th December, but before the 1st of January 48, this was the effect of the dominion of India was vested with sovereign powers, and the ex-rulers were left only with their private property and their annual privy. So where was this loss? This was the effect of the internal sovereignty worked out. And it's all there in the white paper. In Article 317. So where was this loss? The only 2 other states for Hyderabad and internal sovereignty worked out. In Article 370, my lord. And that is why, my lord, I emphasize that 370 is the only 2 other states repository of the merger agreement read with the instrument of accession. And that is why, my lord, I emphasize that 370 is one other repository of the merger agreement read with the instrument of accession. Which is the first privy persons case, my lord. In this very volume, my lord, I want to refer to one other. Starts at
PDF?
It starts at PDF, which is the first privy persons case, my lord. And I want to take your lordship straight away starts at
PDF?
It starts at PDF 390. Of course, the amendment came later. Your lordship straight away taking the Privy Persons Amendment power away.
Page 3.
So, my lord, I'll take, we're still on volume 6, my lord, and I'm taking your lordship amendment came later in taking the Privy Persons Amendment power away.
Page 3.
So, my lord, I'll take, we're still on volume 6, my lord, and I'm taking your lordship to PDF 457. Just one small paragraph. Paragraph 111 on page 1909. PDF 457. Just one small paragraph. Paragraph 111 on page 1909. PDF 457.
Referring to paragraph 11, Mr. Howard?
May I read out, my lord? Para 111.
Yes.
The plea raised by the union must be considered in the light of these developments.
Referring to paragraph
The political
11, Mr.
developments and the history of negotiations and agreements were certainly not intended to be an exercise raised by the union must be considered. The argument of the parties to the instruments, the political developments and the history of negotiations and agreements were certainly not intended and likely to be exercised not by the unilateral. The argument of the Union of India must be rejected. Solemn undertakings intended this is building on Mr. Sibbal's argument and likely to unilateral act by the unilateral. The assumption you don't take into account India must be rejected. So the argument raised by the union, this is building on Mr. Sibbal's argument, my lord. A unilateral act. This is an exercise in futility. Don't take into account history. The response is. So the argument that the parties to the instruments were entering into solemn undertakings intending this is an exercise in futility going back and liable to be set at naught by the unilateral act of the Union of India that the parties to the instruments were entering into solemn undertakings intending the arrangements to be temporary and liable to be set at naught by the unilateral act of the Union of India must be rejected. And that's a mission, my lord, which I will hand over and go through it. One of my arguments, my lord, whether it is done by transformational morality, my lord, because of the antecedents, or whether it's done by mission, my lord, which I will hand over, transformational morality in my view. One of my arguments, my lord, whether it is 370 to that extent is part of the basic structure, because of the antecedents, or whether it is done by substitute for the merger agreement, or which transformational morality in my view is a part. As an interpretation, my lord, 370 to that extent is part of the basic structure. As a substitute for the merger agreement, as an interpretation, my lord. Just hand over that. $356, my lord. Where is it in my? 356, my lord. I'm coming back to volume 1 of the submissions. Where is it in my? The PDF number is 267, my lord. I'm coming back to volume 1 of the submissions. My lord, I put in a table, the PDF number is 267, to show how President's rule has been exercised and Section 92 has been exercised. My lord, it is my respectful submission. I put in a table. They cannot be exercised in tandem to show how President's rule has been exercised and Section 92 has been exercised. My lord, it is my respectful submission. They cannot be exercised in tandem. As it was, my lord, Governor's rule had taken place and now President's rule was imposed. On that, my lord, if your lordships will see, I've given, my lord, all the, as it was, my lord, Governor's rule had taken place, and now President's rule was imposed. On that, my lord, if your lordships will see, except, my lord, all page 276, which is PDF 276, cases that I want to cite, I won't bother your lordships with them.
I'm sorry, Mr.
Except, my
what are you
lord,
referring
page
to?
276, not my submission.
You are referring to
I'm now winding up, my lord.
page number?
Mercifully.
I'm sorry, Mr.
276.
276.
Not my submission.
Your
An important aspect, I'm now winding up. MoMI, of course, is there.
You
Page
can't
number?
remember that in Bomai, my lord, it was just the action of President 276. 32 was not involved in the same extent. An important aspect, relying on 14. Bomai, of course, is there. You Rameshwar remember that in Bomai, my lord, it was just the action of President 32 was not involved in the same extent. But I'm relying on 4.25, Rameshwar Prasad's case. Lordship got it, Lord?
Yes.
It is open to the court an exercise of judicial review to examine the question whether the governor's report is based on relevant material or not. Has your lordship got it? Whether it is made bona fide or not. It is open to the court whether the facts have been duly verified or not. To examine the question whether the governor's report is based on what your lordships have indicated, whether it is made bona fide or not, review, and whether the facts have been duly verified or not. This, my lord, is now what has happened in this case have indicated on the extent of conditionalities for the exercise of 356. All now the documents in this case made publicly available and placed before Parliament. Can lay down conditionalities. In this case, even the governor's report was not placed before Parliament. 356. All the documents must be made publicly available and placed before Parliament. So when your lordship, in this case, even the governor's report is justice was not placed before Parliament. What are the contours of this justiciability? Or before the court. A full, frank and complete disclosure says 356 to Parliament and to the people. What are the contours of this that this is, I've received this message, there it is, and not even to place the frank and complete disclosure. That is why I say, my lord, the entire exercise of Parliament and to the people needs to be examined by just to say that this is, I've received this message. Others will argue, my lord, and not even to place the report. When they that is why I say, my lord, the entire exercise of the president. I'm going to give your lordship needs to be examined by your lordship. By summary, in this case. Others will argue, my lord, give more on this when their turn comes. Now, my lord, I'm going to give your lordship. Because this, my lord, by summary, my lord, is the substance of what I've added to my written submission. Because this, my lord, is the substance of what I've added to my written submission. May I read it out, my lord?
Yes.
India has a multi-symmetrical constitution to be interpreted as transformational in nature. May I read it out, my lord? It's unique.
Yes.
And that is why your lordship insists India has a multi-symmetrical despite the many amendments to be interpreted as transformational in nature. This is a multi-symmetrical constitution. It's unique. My second is why your lordship insists on the instrument of accession represents subject to conditions despite the length. The loss of external this is a multi-symmetrical constitution. Standstill and merger agreement submission finalizes the instrument of accession represents subject to conditions. The loss of external sovereignty. And that, my lord, is to be the internal sovereignty. Standstill and merger agreement finalizes the internal result of a binding historical agreement. The instrument of accession deals inter alia with conditions of external sovereignty found in 370. But in the absence of standstill and merger agreements of a binding historical agreement, a substituted constitutionally consecrated conditions of external sovereignty for finalizing internal and external and merger agreements, resulting in 370 represents interactive, sui generis, constitutionally unlike any other state. Measure agreement is unique and finalizing internal and external sovereignty, and resulting in two basic structure interactive, sui generis constitutions, unlike any other states. 371 part of the basic structure alone survives, and 372 and basic structure and transformational constitutions. Why is this important, my lord? Because 371 1954 alone survives, time, and 373 was used and exhausted therein within 273. Why is this important, my lord? Because the provision is gone, the Constituent Assembly is gone, time, and the substitution is for the Constituent Assembly re-legislature within 273. The provision is gone. How can the Constituent Assembly is gone? 370 the substitution is for the Constituent all of a sudden, years later, after the Assembly is over, and there is a JK Constitution. How can you resurrect, my lord, 370 subclause 3, all of a sudden, years later, after the Assembly is over, and there is the power under 1D is there, my lord, is subject to constraints. I needn't say more than what has been said before.
is subject to its two provisos, with the power, and for the rest of the Constitution is subject to consultation. I needn't say more than what has been said. No, my lord. Article 3, 4, and 3 subject to its two contain mandatory requirements and for the rest of the Constitution on information to be laid before the House and inter alia requiring concurrence and consultation. Article 3, unfortunately, the mandatory requirements contain mandatory requirements the bill to the legislature on information to be laid before the House and by the presidential requiring concurrence and on 19th December 2018. Unfortunately, the mandatory requirements contains both the declaration the bill to the and the extension of was suspended by the presidential proclamation and 2019. 19th December 2018, which is ultra vires. Then, my lord, on President's rule, both the President's rule provisions and the extension of President's rule in 2018, 92, and Section 92 of the JK Constitution. Then, my lord, on President's rule, the President's rule provisions of 3 and 4 and 370 cannot be invoked during 92's rule. And Section 92 of the JK Constitution require the existence of a legislature in tandem, for which the President and Parliament cannot be invoked during President's rule at all, since they require the existence of a legislature. Then President's rule is required by for which the President and Parliament cannot be constitutional, justiciable, requiring objective basis, which includes the Governor's report. Then all material is required by the people and Parliament and Rameshwar Prasad. It is justiciable, requiring objective basis, which includes the Governor's report and all material should be
I was just telling my
placed
colleague that you have really summarized very
justice.
precisely all that you have argued. We've taken down what you have argued, but now this formulates
We
it.
read it out, Manoj.
Certainly.
And then I'll sit down. And that's
No, I was just telling my colleague that you have really summarized very precisely
No,
all
no.
that you have argued. We've taken down what you have
Article
argued, but now this
370.
formulates it.
So I've said all the materials, Manoj.
Certainly.
And then Article 370 can be amended, subject to the caveat in CO 48 that all amendments relating to JK. So I've said all the procedure in Article 370. Article 370 can be, it is not enough amended. 273 to the caveat all treaties are out of the Constitution. That all amendments relating to JK must follow the procedure in Article 370 subclause 1. Many federations not enough. Have in 273 says all treaties are out of the Constitution is gone. And JK, because of its nature, my lord, disappear like this. Accordingly, 272 and many federations are invalid as being excessive, and the state constitution. JK reorganization and JK, because of its nature, my lord, 3 and 4, as going beyond the mandate 2 and 273, and in violation of the being excessive, and wrongly suspended reorganization presidential notification under 3 and 4 as going beyond the mandatory provision. I ask, and in violation of the process of Article 3, my lord, your lord, wrongly your lordship's question, what was the presidential notification of 19th of August?
That's
My
point
lord,
9.
Mr. Zafar Shah, my lord, will give your lordship's a detailed account. This is my summary question. What was lost? The loss of statehood on 4th of August. By
That's
degrading
point
it, Mr. Zafar Shah, my lord, will give your lordship's a detailed account.
Itemize this.
This indirect abolishment of the JK. What was lost? The loss of statehood, loss of residuary power by degrading it to union territory, loss of territory contrary to the JK Constitution, Section 3. Indirect abolishment of the JK Constitution, Section 4, sorry. Abolition of mandate, loss of residuary concurrent and consultation provision, loss of territory, conversion of the JK Constitution Section 3 without adequate safeguards, Section especially for JK, abolition of mandatory informatory constitution without a proper amendment and consultative conversion of state and concurrent procedure of Article 370, for which CO 48 was added to 368. The right of permanent residence amendment and consultative process on the right to concurrent procedure of Article 370, for which CO 48 was added. Article 31 was not suspended. Only the right of permanent residence remained of JK. In the light of the above, it is pleaded restore statehood. Because 31, my lord, permit the continuance of the JK. Only the later article 31 remained. Have immediate elections. In the light of the above, it is pleaded abrogate. Restore statehood. This is what I have to say. I'm sorry. Permit the continuance of
Thank you, Dr. Dev. Thank you very much, Doctor.
Have immediate elections under the JK Constitution, abrogate President's rule. This is what I have to say. I'm sorry I've stepped over my time.
Thank you, Dr. Dev. Thank you very much, Doctor. Yeah.
Allow me to begin with this, Lord, profound words of Justice Aaron Barak, Lord, the President of the Israeli Supreme Court. Lord, he was reported in Harvard Law Review. Allow me to begin way back in 2002. Lord, profound words. Since, Lord, we are expounding Constitution. These are extremely President of the Israeli Supreme Court. And I quote him, the task of expounding a constitution back in 2002 is crucially different we are expounding from that of construing a statute. These are extremely a constitution is drafted. I quote him, with an the task of expounding a constitution, its function is to provide a different framework from that the legitimate exercise of a constitution is drafted with an eye to the future. 370, its function is to provide a continuing framework for the legitimate exercise on the part of the constitutional frameworks. Now, Lord, 370, you are at a time is when perhaps the most brilliant in Kashmir are being raised. Articulation. You are at a time when raiders are raiding Lord in plain clothes and trying to take away. You are at a time when Maharaja is uncertain whether he wants to join the dominion of India or Pakistan. You are at a time when Lord India is just being born as a Lord dominion. You are at a time when Maharaja is uncertain whether he wants to join the dominion of India. It was a brilliant compromise that was. You are at a time when Lord India is just which Lord led to Lord producing this article. At a time persuaded the people of Jammu and Kashmir. Brilliant compromise that was arrived at. Which gave them a promise producing this article, which persuaded in the manner that Jammu and Kashmir, or for that matter, at any point of time. And that's why them a promise. Dr. Dhawan very rightly cannot breach that ultimately in the manner that you have. Or for that matter, the Constitution deals with this kind of diversity. And that's why what Dr. Dhawan very rightly to start tinkering with, ultimately nothing will be left of the article of the Constitution deals with this kind of diversity. And my respectful submission to start tinkering with submissions, nothing will be left of the Constitution. That Article 370 is a piece of consider unusual draftsmanship. It is temporary. But it is not temporary by a flux of time as most temporary statutes. Unusual. It is temporary by object. It is temporary. But it is not temporary by a flux of time as is achieved. Once that purpose is subserved, it is temporary by object. Nothing remains for the president to exercise. Once that object is achieved, once that purpose is subserved, then, Lord, nothing remains. It's going to be my respectful submission that 373, Lord, has served its purpose. The day Constituent Assembly of Jammu and Kashmir agreed. It's going to be my respectful submission that 373 Lord, has served its purpose, subject to following modification, and President accepted, agreed that modification. Yes, Article 370 must remain on the Constitution of India, subject to following modification, and President accepted. Your Lordships have taken the view right from Federal Court, and I will show CO 44. That temporary statutes, Lord, General Clauses Act does not apply. Lord, your Lordships have taken the view right from Federal Court. Then, Lord, the exercise is one-time exercise. Temporary exercise it again and again. General Clauses Act does not. It was never intended to be exercised again and again. If that is so, then, Lord, the exercise is one-time exercise. You cannot exercise it again and again. It was never intended to be a continuing exercise on a demurrer. In my respectful submission, then, Lord, the only way Parliament could do it is if it is amending the Constitution on a demurrer 368 and repealing Article 370. Then the only way Parliament could do it, and I will show Lord that's the view amending the Constitution under Article in Berubari's case and repealing Article 370 interpreted a treaty and said that you cannot do this. And I will show Lord that's the view Lord 8 of your Lordships have taken in Berubari's case, where your Lordships interpreted a treaty and said that you cannot do this. Respectful submission for your Lordship's kind acceptance that the exercise of powers by the president on 5th of August and 6th of August
And lastly, it's going to be
my respectful submission for your lordship's kind
are
acceptance
nothing but fraud on the
that the
Constitution.
exercise of powers by the president on 5th of August and
As
6th of
Dr.
August
Dhawan rightly
2019,
points out,
there is nothing on record
are
why
nothing
a
but fraud
provision
on
which
the
has
Constitution.
successfully survived from 25th October
As
1947
Dr. Dhawan rightly points
till
out,
there is
6th of
nothing
August
on record
2019
why
should have
a
been
provision
repealed
which has
as they
successfully
claim, or should have
survived
been withdrawn.
from 25th October 1947
There was no material
till
whatsoever.
6th of August 2019.
The only material with
should
respect
have been
was
repealed
as they
that
claim,
the
or
ruling
should have
party
been
in its
withdrawn.
manifesto in 2019 had
There
said,
was no
we will
material
abrogate
whatsoever.
Article 370.
The only material with
Your
respect
lordships in DC
was
Madras case have
that
said
the ruling
that
party
you
in its
cannot
manifesto in
exercise
2019
constitutional
had said,
powers
we
to
will
achieve
abrogate
political
Article
ends.
370.
Your lordships in
Lord,
DC
it's a
Madras
classic
case
case
have
of
said
fraud on Constitution.
that you cannot exercise constitutional powers
So,
to achieve
Lord,
political ends.
You have a government
In
Lord, it's a
association
classic
with a
case of
local
fraud on
party in
Constitution.
Jammu and Kashmir, it is working well. You suddenly
So,
withdraw
Lord,
the support from that government.
You have a government.
Then you persuade the governor to issue a
association
president to issue a
with a local
356
party
order.
in Jammu and Kashmir.
Then you
It is
persuade president
working
to
well.
issue a resolution
You
of
suddenly
the
withdraw
assembly.
the support from that government.
Then you persuade
Parliament
the governor to
apparently
issue a
takes
president
control
to
of
issue a
legislative and
356
executive
order.
functions.
Then you
persuade
say
president
now
to issue a
president will exercise
resolution
all
of the
powers
assembly.
into one.
And
Lord,
Parliament then
apparently
what
takes
more
control
classic
of legislative
example
and
of
executive
abuse of power
functions,
than this?
and then you say now president will
Lord, as
exercise
Chief
all
Justice
powers
Coke said
into
to
one.
way back when
And
the fight
Lord
began
pass
with the
orders
king,
under 370.
that Lord
Lord,
King
what
can do
more
everything
classic
except making
example
a
of
man,
abuse
a woman,
of
and a
power
woman
than
and
this
this can.
Lord, surely
Lord, as
president
Chief
could
Justice
not
Coke
have
said,
Lord,
Lord,
exercised
when
this
the fight
powers
began
under
with the king,
370.
Lord,
Assuming
King can do
himself to be
everything
everything, making a man a woman and a woman a man.
What? Lord,
Yes,
surely
Lord,
president
has
could not
been
have
pointed
Lord,
out at
exercised
great
these
pains and
powers
very
brilliantly.
373,
Lord,
assuming himself to
356
be
is a
everything.
temporary provision. What? Lord,
Now, Lord,
yes,
356
being a
been pointed
temporary
out at great
situation,
pains and very
can you
brilliantly.
take actions which are
That
permanent?
356 is a
permanency
temporary
or
provision.
permanent in nature?
Now, Lord,
Forget anything
356
else. Being a temporary
because, Lord,
situation,
356
can
itself
you
says
take actions
that
which are
everything that you have done in the
permanent or
interregnum will come
permanency
to an end?
or permanent in nature?
And maximum period for which you can
Forget
exercise
anything
356 is 3
Because
years.
Lord 356 itself says
That everything that you have done in the
So,
interregnum
Lord,
will come to an
to
end.
do this, Lord, in my
And
respectful
maximum period for
submission,
which you can
it
exercise
really
356
strikes
is 3
at
years.
the very basic Lord features of our constitution. So, Lord,
Democracy.
to do this,
Lord, in my respectful
federalism,
submission,
it really strikes at the very basic Lord features of our constitution. Democracy, federalism,
Lord, Government of India in their affidavit before your lordships categorically admits this, and this is very important, Lord, the counter, which I'll read at the Lord appropriate stage. That Constituent
Government of
Assembly of
India in
J&K
the
did
before
not
lordships
in any manner
categorically
deviate
admits this,
from the
and this is very
provisions of the
important,
Constitution
the counter,
of India,
which I'll read at
would
the
be
Lord
applicable
appropriate
to
stage.
J&K. That Constituent Assembly
This
of
is their
J&K
thought,
did
profound
not
statement.
in any manner
Then
deviate
Lord, they
from
try,
the provisions of
and
the
Lord, they
Constitution
say
of India,
that, Lord,
which would be applicable to
ultimately,
J&K.
that what we have done is,
This is their
because
thought
of
profound
national
statement.
interest.
Then, Lord, they try. And
nobody
Lord, they
knows
say
what this national
that, Lord,
interest is because it's not been
ultimately
defined in the
that
draft
what
directive.
we have done
No
is
material whatsoever.
because of, as I
National
said, Lord, it
interest.
has survived. Of course, there is insurgency. Nobody
Nobody
can deny that.
knows what
But
this
then we have
national interest is
insurgency in
because
so
it's not
many
been
states
defined
in
in the
northeast
draft
India.
affidavit. There was no
We had
material
insurgency in
whatsoever.
Punjab for a long
As
time.
I said,
Lord, it has survived. Of
If
course,
we were
there
to
is
start
insurgency, nobody can deny
disintegrating
that.
states
But
into
then we
union
have
territories
insurgency in so many
manner,
states in
no
northeast
state
India.
will be saved
We had
in this
insurgency in Punjab
under
for a long
political,
time. Class that
If
we
we
have
were to
today.
start not disintegrating
Tomorrow
states
it may
into
so
union
happen that
territories in this
my party
manner,
cannot get
no
elected
state
in
will
a
be
state.
saved in
I
this
will disintegrate
under
into union
political,
territories. Class that we have today.
because there is law and order problem.
Tomorrow it may so happen that my
This is
party
something
cannot
which your
get
lordships
elected in
will have
a
to
state.
very seriously
I will
consider. It's
disintegrate
not
into
just
union
one
territories.
time exercise. Because
It has
there is
such
law and order problem.
ramifications for future of India, for the
This is
constitution
something
of
which
India,
your
for
lordships will have to
federalism,
very
for very
seriously
existence.
consider. It's not just one
That
time
it will
exercise.
really, it has
Giving
such
now this kind of a
ramifications
power
for
to
future
not
of
a
India, for the
majoritarian
constitution of
government
India, for
will be
federalism,
destructive
for
of
very
rule of law.
existence.
That not
It will be really
terribly
be
destructive
giving
of
now
rule of law.
this
When I
kind of a
beseech your
power
lordships, that's
to
why
not
a
a
majoritarian government.
Your lordships
will
will
be very
destructive
beautifully
of
put
rule
it.
of law. That constitutionalism demands
would
that
be
your lordship should
terribly
oversee
destructive of
every
rule of law. And I
act
beseech
of
your
the
lordship,
parliament
that's
and
why
the
I go
executive.
ahead.
Your
And
lordships
the moment
your
your
lordships
very
will
beautifully
find
put
that
it,
there is
that
infraction of constitutionalism demands that your lordship should oversee every act of the parliament
to
and
create
the
for
executive.
this atmosphere
And the
of
moment
fear,
your lordships
Lordships
will find that there is
Nobody
infraction
could-
of
one thing I
constitution,
must tell your lordships,
will
very
come down
interesting,
heavily.
Lord. Very few people, Lord, way back
like to create
on
this
27 May
atmosphere of fear
1949 on the Constituent Assembly.
Nobody,
Lord,
one
a
thing
debate
I
was
must
going
tell your
on
lordships,
about
very
interesting,
interesting. Four
Lord. Very
representatives
few
of
people
JNK who had
Lord,
not
way
been
back
invited so far.
on
Question was
27
whether
May
they should be
1949
nominated or
in the
not, because
Constituent
everybody
Assembly,
felt that they should
Lord,
be
a
present.
debate was going on
So,
about
Lord, Mr.
bringing
K.T.
four
Shah was an
representatives
advisor
of
to
JNK
government of
who had
Jammu and
not
Kashmir
been
and who had
invited so
Professor
far.
K.T. Shah had
Question
worked
was
there very
whether they should be
extensively.
nominated
He
or
made
not,
this
because
statement,
everybody
which was
felt that
very
they should be
interesting,
present.
which was
So,
perhaps
Lord,
quite,
Mr. K.T. Shah was an advisor to
inappropriate.
government of Jammu and
He
Kashmir
said
and
it
who
has
had
been the
Professor
declaration
K.T.
of
Shah
highest
worked there very
authority of India.
extensively.
And
He
also
made
that
this
of
statement,
accession
which
of the
was very
statement by the
interesting,
Maharaja,
which was
who was the
perhaps
complete
quite,
constitutional head on the day. That
inappropriate.
accession was agreed
He
to.
said it
Was
has been the
subject to
declaration of
confirmation
highest
by result
authority
of
of
India.
plebiscite.
And also that of accession
Now
of
please
the
see
statement by the
Pandit Jawaharlal
Maharaja,
Nehru's
who was the
retort
complete
to that.
constitutional head on the
Jawaharlal
day.
Nehru
That
retorts by
accession
saying
was
this is
agreed to.
absolutely
Was subject
incorrect.
to confirmation by result of
100%
plebiscite.
incorrect.
I am amazed.
Now please see
surprised and
Pandit
astounded
Jawaharlal Nehru's
that such a
retort
statement
to
is
that.
made by Professor.
Jawaharlal Nehru retorts by
Why?
saying this is
Because
absolutely
Kashmir
incorrect.
has certainly become
100%
part of India, and
incorrect.
it will always
I am
be a
amazed,
part of India.
surprised
Nobody
and
denies
astounded
that. That such a statement
Once
is made by Professor.
Article
Why?
Section 3
Because
of the Jammu and
Kashmir has
Kashmir
certainly
Constitution
become part
itself
of India,
provides
and it will
that we are
always
part
be a
and
part
parcel
of
of India.
India.
Nobody denies that.
Question is
that when
Article
Section 3
you
of
have
the
now
Jammu and
got,
Kashmir
as your lordship
Constitution
said, very
itself
rightly
provides
question about
that we are
sovereignty.
part and parcel
Lord,
of
you
India.
can acquire a new land by
Question
either
is
accession
that when,
or by cession
you have
or
now
by
got,
occupation.
as your lordship said very
In
rightly
each of
question
these
about
cases,
sovereignty.
Lord, you can acquire a complete new land
as by
by
either
either
accession
accession
or by
but
cession
what happens in
or
a
by
situation like
occupation.
this, where you
In each of
have
these
agreed
cases,
as a
Lord, you can
as a
take
nation,
complete
as a
sovereignty,
dominion,
as
a
Lord the
state
Chief
taking
Justice
over
observed.
that territory.
But
That
what
I
happens in a
take your
situation like
territory
this,
subject to
when
this
you
condition.
have agreed as
What
a,
happens then?
as a nation, as a dominion, as
There,
a state
Lord,
taking
everybody
over
says
that territory,
that you
that
cannot
I
now get out
take
of
your
this
territory subject
And
to
the
this
only way you
condition.
can do it
is by amending
What
the
happens
Constitution.
There, Lord,
Now
everybody
you
says
don't want to amend
that
the
you
Constitution
cannot
of
now
India
get out
because
of
then
this
you have to
condition.
follow the
And
procedure.
the only way you can
need
do it
two-thirds
is by
majority in
amending
both
the
houses.
Constitution.
You may even need
Lord, to go
now
to the
you
legislatures
don't
of the
want to amend the
state because you are
Constitution of
taking
India
away
because then you have to
representation
follow
of
the
the
procedure.
state in Lok Sabha
You
and
need
Rajya
two-thirds
Sabha.
majority in both houses.
So you will need
You may even need
50% of the states to agree to the legislatures of the state because you are taking away representation. These are the safeguards in Lok Sabha and Rajya Sabha. If these safeguards are thrown out of window in this light manner, who else can protect except your lordships? So what? These are the safeguards. It is very therefore important for us to understand that this is not just about Jammu and Kashmir. Who else can protect except Jammu and Kashmir was, is and will always remain part of India. It is very therefore important for us to understand promise that India made to Jammu and Kashmir. This is not just about Jammu and Kashmir, which came about. Jammu and Kashmir was and is and will always remain part of those terms and conditions. But Lord, so Lord, your Lordship promise that India made to Jammu this constitutional provision, which in my respectful submission is terms and I must tell your Lordship that Premnath first. Your Lordships are called upon to expound this constitutional provision, which in my respectful submission is, and I must tell your Lordships that Premnath first, Constituent Assembly has given that assent. Yes, we have all agreed the confirmation by the Constituent and President has accepted. I will show those passages. So therein says your Lordship said in these two Constituent Assembly has given that assent. Complete finality to what is the eventuality and President has accepted. So both ways your Lordship. So Lord, in my respectful submission, Lord, this calls for a very different kind of approach than what government of India would like your Lordships to take. So Lord, in my respectful submission, this calls for a very different kind of approach than what government of India would like your Lordships to take. They have to be. These are durable provisions. They must. I would say they must go through the test of times. That's not how if merely because something has happened or is happening in Jammu and Kashmir, you have to do this. They must happen in another state. They must go through the test of time. Do that again. If merely because something has happened, the power or is happening in Jammu and Kashmir, you have to do this. Certain situation prevailing at a particular you might be called upon to do constitutional provisions can't be tinkered with. So the power. So how do you make them durable? Because of you make them durable by situations prevailing at a particular. But the need of the hour was that we wanted Kashmir to get into us. So how do you make them durable? So at that point of time, we were left with no option but to accept that we wanted Kashmir to get into us. Run away to Jammu and Kashmir. There was one fear. So at that point of time, we were left with no option but to accept. Nobody knows what exactly was happening. But who were the people who really were? There was one fear. That is the constitutional framers. And Dr. Iyengar's exposition of exactly was happening. But who were the people who really were aware? I am conscious that Constituent Assembly debates may or may not be relied upon. Dr. Iyengar's exposition gives a complete answer to what government tells us on North 370. He also says that all that we need is the wishes of the people expressed to a Constituent Assembly. It gives a complete answer to what government tells us on North 370. He says that read that all that we need is the wishes of the people expressed to one looks at this provision in my respectful submission. This controversy needs. He says that, and I read that delicate two-paragraph approach from your Lordship, so that one looks at this provision in my respectful creating a situation controversy needs. Let us assume for the sake of delicate approach from your Lordships. So that we do not end up. Tomorrow, somebody creating a political party in power with majority. Let us assume take a decision which is not in national interest. This decision is in national interest. You have to therefore lay down law. Tomorrow, somebody other all these political parties in power with majority, and that's why take a decision which is not in national interest. And I beseech your Lordships with all humility. You have to therefore lay down law which will stop all these exercises. Now, take therefore and that's where in this regard, Lord, kindly turn and I beseech your Lordships with all humility and judgment of your Lordships may therefore look at it as compilation of judgments. Take therefore in this regard, you can also kindly turn straight away. You can add one judgment of your. We can. It is already with Prasanna. I can add them with just in 1 second if your Lordships permit. You can add them.
It's part of the existing compilation.
Already with Prasanna. I can add them with just in 1 second if your Lordships permit.
It's part of the existing compilation. So what is volume 29? We stop at volume 28.
Learned Courtmaster, volume 30. These are judgments only. Case law compilation.
So what is volume 29? We stop at volume 28.
29 and 30 have not been allowed. These are judgments only.
Judgments are in the compilation?
Dr. Thomas is.
Mr. Dave.
Sorry, Mr. Dave,
No.
I'm sorry.
Many of them are, but 5 of them are not.
Judgments are in the
Your
compilation?
Lordship knows not, our research goes on all the time.
Dr.
That's
Thomas is.
Mr. Dave, but at some point, Mr. Dave, you have
No,
to freeze it all, otherwise,
Many
you
of them
know.
are, but 5 of them your Lordship can't certainly stop us from
Why not?
citing judgment.
But we had-
Submissions, yes, I agree. But not
Even judgments,
judgments.
that's frozen when you at some point in time, freeze it all, otherwise, you know.
Judgments. Let me tell you, Lordship, certainly stop us from.
Why
Because
not?
this is a thinking
But
process.
we had-
Submissions, yes, I agree.
Thinking.
But not, and
even
constantly
judgments,
rethinking and
frozen when you
rethinking and
submit
rethinking.
written, the compilation.
It's not to find 5 judgments, I have seen more than 500 judgments, I can assure you. We are constantly thinking. And constantly rethinking and rethinking
Then
and
we think, keep
rethinking.
on thinking, not produce any judgment,
Not
keep on
to
thinking only.
find 5
All that
judgments,
is
I have seen more than 500 judgments, I can assure you. Certainly we'll be thinking many a times over.
Ourselves on the lighter side.
But at some time, we
We
have to
think, keep
also
on
say, all
thinking,
right,
not
now,
produce any judgment.
this is the guillotine, I'm not going to think anymore.
Lord, your Lordship, once the matter ends, certainly we'll be
But,
thinking many a times over.
So many of your judgments are repeated. At some time, we have to also say,
We
all
are not
right, now.
repeating,
This
those
is
are
the
there,
guillotine.
those are
I'm not
there
going to
which
think
are
any
not.
more judgments which are not
Alright,
in.
when I,
Then
my
this is the judgment.
arguments are beginning.
All right,
Judgments
but,
which are already given, I am
So
not,
many of your
not,
judgments are repeated in the compilation already.
I am
given.
not repeating,
So
those
then
are
which-
there, those
then
are there
five,
which
which
I
are
am
the
not.
5 judgments which are not in, then
Yes.
just the judge.
Judgments which are already given, I am not.
Actually, the back office work has to be done before the argument.
Much before the arguments, otherwise it becomes
So
impossible.
the way the problem is, if you are a singular counsel arguing.
Lord, once the debate begins in the court, your Lordships put
Actually, the
questions.
back office
No,
work
so
has
the
to
way
be
what
done
happens is
before the
that's why
argument
much
starts.
before the
Don't
argument,
do this.
otherwise it
Then
becomes
essentially
impossible.
The way the
Difficult
problem
matters
is, if
will
you are a
never get
singular
argued because
counsel arguing.
Lord,
the
once
whole
the
purpose
debate
is to
begins in the
restrict
court,
time.
your
If you
Lordships
don't
put
restrict time, you
questions.
cannot carve out time for that matter. That's why
I
if
have
you
promised
don't
1.5
do
to
this,
2 hours,
then
I'll finish it.
essentially difficult matters
I'm
will
not
never
going
get
to take
argued
you-
because
Because the way, if
the
you
whole
are the only
purpose is to
counsel,
restrict time.
it
If you
doesn't
don't
really make
restrict
so much
time,
of a
you cannot
difference.
carve out
Because
time
you
for
added
big
something
matters.
subtracted
I have
something.
promised 1.5 to
Then the
2 hours,
multiple
I'll finish
counsels,
it.
10 counsels,
I-
12
I'm not
counsels,
going to take
each
your
person
time.
starts doing it. Where do we go? This is the concern only. It doesn't
No,
really,
but
not that we wanted to shut
Law
out issues and
declared
you
by
added
this
something
court, my Lord, your
subtracted
Lordships
something.
would always like
The
to see.
multiple counsels,
It's law
10
declared by your
counsels, 12
Lordships
counsels.
court, my Lord.
Each person starts doing it. Where do we
there
go?
has to
This
be
is the
a
concern only.
certain
It is not that we wanted to shut
Law
out.
declared by
orderliness
this
in
court,
making
my
Every
Lord, your
year
Lordships would
SEC,
always like to see. It's
on
law
like
declared by
creates
your
some
Lordships
19, 20
court, my Lord.
volumes. This is another problem.
I mean,
Well,
there
I'm
has to
sure,
be
Lord,
a
your Lordships
certain
directed us to
procedure
give
also,
submissions.
and
I
orderliness
never
in
thought that
making
about so
Every
far as
year
judgments
SEC,
are concerned, because it's a constant
creates
research.
some 19,
Nobody
20
cannot
volumes.
do it
This is
at
another
one
problem.
go. Well, I'm sure you are trying to find out again and again and again answers, questions fall from your Lordship's concerned, because it's a constant research. That nobody can rightly asked about sovereignty. You are trying to find out again and again and again answers, questions fall from your Lordship's bench. So brought to that, your Lordship
volumes,
rightly asked about
Mr.
sovereignty. I don't know, 29 is by.
29 is Mr. Nafta's. That is also not been allowed by the board.
This is the problem. How can we do this?
Then how many volumes will we have actually?
Okay,
2 volumes,
it is
we actually having
problem.
1 volume
I don't
now
know,
of
29 is
case law.
29 is Mr. Nafta's. That is also not been allowed by the board.
This is the problem.
My 28 was
How many
allowed
volumes
already
will we have
earlier, but
actually?
30
Actually,
is
We actually having 1 volume now
How many
of
judgments?
case law.
28 in the-
I have brought printed copies also, if your Lordships like. My 28
So volume
was allowed
30 is
already
5
earlier,
judgments.
but 30 is brought an additional one. How many judgments do you have? 30? I have brought printed copies also, if your Lordships like.
So volume 30 is 5 judgments.
5.
'29 also has just case law, right?
Yes, yes, ma'am. There are no submissions. These are only judgments. 28, 29, 30 are case law compliance.
29 also has just case law, right?
Yes, yes, ma'am. There are no submissions. These are only
Submissions.
judgments. My apologies for it, but
What sauce for
28,
the goose is
29,
not
30
sauce
are
for the
case law
gander.
compliance.
So you will not.
I'm sure, Lord, Mr. Mehta will definitely like to cite
my
some new
apologies for it,
judgments to counter us.
Whatsoever.
For the
He's
goose
not
is
saying
not
that I'm
sauce for
going
the
to cite
gander.
it. Don't give him ideas.
But his smile tells us, I'm sure, Lord, Mr. Mehta will definitely like to cite new judgments.
What is it that you want to cite?
counter
All right,
us.
think so. He's not saying that I'm going to cite it. Don't give him ideas.
His
Why don't you
smile
give us
tells us
the
otherwise.
soft copies?
My learned friend has signed.
What is it that you want to cite? All right, Mr.
It's
Dave,
in the
let's
drive,
quickly run
yes.
through it. Give us, give us those, why don't you give us the soft copies? Judgments or?
No, yes, Lord, I would like to.
Huh?
It's in the drive.
Judgments or? That you want to,
No, yes, Lord, I would like
why don't you then give the judgments? In 10 minutes that we have today, you can really give us the framework. What are the judgments you want to cite? What is the principle? Just formulate you want to. Why don't you then give the judgments? In 10 minutes that we have today, you can really give us the framework. What are the judgments you want to cite? What is the principle? Then what are the judgments? Just tell us the citation. Volume 29 page.
1959.
Volume 30, right? Volume 30.
Is a
Just give us the PDF page. Right. Then what are the judgments? Just tell us the citation.
16161.
Volume 29 no, it can't be 16161.
1959.
Volume 30, right? Volume 30.
Page 2.
Just give us the PDF page.
Volume 30, page 2. PDF page 16161.
No, it can't be 16. Volume, what is the site? What is the name of the
This
case?
is Dalmia Dadri Cement versus CIT. This 30 interpreted this very broad letter of accession and
Volume,
said that this
what
is
the
a
site?
treaty.
What is the name of the
This
case?
is Dalmia
Para?
Dadri Cement versus CIT. Paragraph this interpreted by this very broad letter of accession.
8.2.
And said that this is a
Why
treaty.
don't you read out the relevant
And
part?
Lord,
Mr. Para?
yes. Yes, Lord, paragraph
Yes.
3, 5, now Lord here, and your lordship say 8.2. What
8.2.
fell from the Honorable Chief
Why
Justice.
don't you read out the relevant part, Mr.
Yes, sorry.
What did it interpret, you said? Yes.
Lord, interpreted here, the accession agreement, what fell from the Honorable Chief Justice.
What did it interpret?
Held it to be a treaty.
What did it interpret,
And
you
then
said?
said sovereignty should transfer the accession agreement.
Sovereignty transferred.
Yes, and Lord held it to be a treaty. In the subsequent sovereignty should transfer. Lord, in
Sovereignty
Berubari,
transferred.
which is already on record.
Now, Berubari,
But,
where
Lord,
did we get the
In the
citation?
subsequent case, that Lord, I'll tell you, Lord,
Which case law compilation?
PDF Lord, in Berubari, which is already on record. It is
Now,
PDF
Berubari,
page
where did we
13.
get the citation?
Yes, CLCP 492. I'll tell you, Lord.
Which case law
Volume
compilation?
13, page 492. PDF
Volume
page
30 or 13?
13.
Volume?
Yes, Lord. It is PDF
Volume
page
13 page?
92. CLCP 492. 492.
No, what is the
Lord,
volume?
this will have to be read in extenso because this is a
30 or 13
brilliant
you
Lord exposition of a treaty.
Volume 13
And
page
why, my Lord, your lordships held that you cannot get out of this treaty
Lord,
except by constitutional amendment. Because this is a brilliant Lord exposition of a treaty. And why, my Lord, your lordships held that you cannot get out of this treaty except by constitutional amendment. Give me the page when I actually interpret the opposition.
Volume 30.
Don't ask.
Volume 13?
I, Lord, your lordship knows, Lord, that Mrs. Dave had to assist me. Your most embarrassment to your lordship. Don't ask.
Volume 13?
Lord, your lordship knows, Lord, that Mrs. Dave had to assist me. My Lord, that's why I proudly call myself technologically.
So simple, Mr. Dave. Just try, give it a try for one day, and you'll never go back.
My Lord, that's why I proudly call myself technologically.
It's so simple, Mr. Dave. Just
Among the mind blocks I had,
try, give it a
tell
try
Chief,
for one
don't
day, and
deprive me
you'll
the privilege
never go back.
After a miscellaneous matter, throwing the file down. Only privilege judge has after a badly argued matter. Among the mind blocks I had, certain these kind of matters, after a miscellaneous matter, throwing the file down. The volume becomes so many. In a small matter is fine, but a bulky matter, it works better. But in these kinds of matters,
We are encouraging you, Mr. Dave,
last
that
time I
please
realized that the volumes become so many,
get on
In
board.
a small matter is fine, but in a bulky matter, it works better.
But that is what your senior is relaying to you. You have to give it to us yourself. Please get on board.
Well, I am giving your lordship PDF pages.
But that is what your senior is relaying to you. You have to give it to us yourself.
Yes, madam. I turn to that word I don't take away, please from me.
Volume 13, page 492. Berubari.
Yes, madam. I turn to. In view of our conclusion. Yes. Yes. Lord, Lordships. Lord, Lordships. What para 31? My lords have heard it. May I read it, please? What then is the nature of the treaty-making power of a sovereign state? That is the next problem with which we must consider before addressing ourselves to the questions referred to us for our opinion. What then is the nature of the treaty-making power of a sovereign state? Sovereignty. That is the next problem with which we must consider before addressing ourselves to the questions referred to us for our opinion. As we have already pointed out, it is essential treaty-making sovereignty. Cession of a national territory in law amounts to transfer of sovereignty over the said territory by the owner state in favor of another state. And this can be done in exercise of its treaty-making power. Such cession is possible. Cession and indeed of a national territory in law amounts to transfer of sovereignty over the said territory. It is true as Oppenheimer has observed that hardship is involved in fact. There can be no doubt cases of cession is possible, and the inhabitants of the territory remain lose their old citizenship. It is true as Oppenheimer has observed that hardship is involved in fact. In all cases of cession, that it may be possible to mitigate this hardship by stipulating an option to emigrate within a certain period in favor of the inhabitants of the ceded territory as means of averting the charge that inhabitants are handed over to a new sovereign by stipulating an option to emigrate within a certain period in favor of the inhabitants of the ceded territory as means of averting the charge that inhabitants are handed over to a new sovereign territory by one country to the other. Now there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to the limitations that a sovereign state can exercise its right may either expressly or by necessary implication. This power, it may be added, is of course subject to the limitations treaties can be made by a sovereign state in regard to cession of national territory or by how treaties when made can be implemented would be governed by provisions in the constitution of the country. To how stated broadly, treaty-making power would have to be exercised in the manner contemplated and how treaties when made and subject to limitations imposed by provisions in whether the treaty made can be implemented by ordinary legislation. Treaty-making power would have to be exercised in the manner contemplated by on the provisions of the and subject to limitations imposed by whether the treaty made can be implemented by ordinary legislation or by constitutional. In dealing with this aspect, we are proceeding on the assumption that some legislation is necessary. We must therefore now turn to the aspect. Then Lordship may omit 5-7 lines and please come to the words unlike other federations. Proceeding on the assumption that some legislation is necessary to implement the agreement in question. Then Lordship may omit 5-7 lines and please come to the words unlike other federations.
Called the basic structure.
Correct.
But before that, something very interesting. The learned Attorney General asked us to bear in mind the special features appearing for the Union of basic India structure of the Constitution. That there is something called the basic the relevant provision of Article 3. They see that the learned Attorney General asked us to bear in mind is the same as that of the Government of India Act 1935 of the Constitution in construing the relevant provision of Article 3. He contends that the basic structure of the Constitution is the same as that of the Government of India Act 1935.
That's how, not right, 60. 60, right?
Yes.
60. Mr. Setal, now please see, Lord. Unlike other federations, the federation embodied in the said act was not the result of a pact or union between separate independent communities of states who came together for certain purposes. Unlike other federations, and surrendered a part of their sovereignty. Embodied the constituent units of federation were deliberately created and union significant that they, unlike the units of other federations, had no organic roots. Hence, in the Indian surrendered a part of their sovereignty with other the constituent units of federation on preservation of the territorial significant that they, unlike the units of state federations, had no organic roots. Hence, in the Indian constitution, but now Lord kindly turn to paragraph 44 at page 515 of constituent states is absent. Now, Lord, this is important. But now, Lord, kindly turn to paragraph 44 at page 515. Yes. How does it begin?
Just read the lower portion.
Yes.
Also.
Just read what, Lord?
The paragraph 32, the lower portion.
In fact, you can start reading.
Just read the lower
in fact, it is well known, and then go to the end, as my learned brother says. In fact, it is well known. Last 10 lines. In fact, you can start reading.
Yes.
In fact, it is well known, and then go to the end, as my learned brother says. In fact, it is well known. Last 10 lines.
That as a result of States Reorganization Act in place of original 27 states and one area which were mentioned in Part D in first schedule to the Constitution, there are now only 14 states and 6 other areas which constitute Union territory as mentioned in first schedule. The changes thus made clearly illustrated the working of peculiar and striking. There are now only 14 states and 6 other areas which constitute Union territory as mentioned in first schedule. In construing Article 3, changes thus made clearly illustrated the working Constitution contemplated changes of territorial limits. There may be some force in this contention, and there was no guarantee about their territorial that in construing Article 3, we would question is, can they be turned into Union territories? Contemplated changes of territorial limits of the constituent states, and there was no guarantee about their provision. And the word, if your question is to read the word Union territory for every word state in the Article 3D, no then the result will be express provision. Very, very and the word unbelievable. If your lordships were to read the word union territory for every although the explanation says that state includes union territory, then result if you were to read it, absolutely very, very unbelievable.
Not to interrupt, but if it can be done for the
So,
state, why not for union
although the
territory?
explanation
Until
says
unless
that state
is
includes union
something
territory.
you can make out
But if you
otherwise,
were to
and when
read
the
it,
explanation goes, explanation says state and union territories use interchange.
Lord,
why not for
I
union
must tell you,
territory?
lordships,
Until
I am
unless
not dealing with that
is
part of the
something
argument which has
that's
been
right,
very
otherwise
beautifully
then
done
the
by
explanation
my
goes.
worthy predecessors.
says state
But Lord,
and
I
union
must tell you,
territories
lordships,
use
that
interchange.
what is really worrying me is this. Your lordships are right, it can be done. Of the argument which has been very beautifully done.
then we come down.
If it can be done in Jammu and Kashmir, but Lord, I must tell you, lordships, that what is really worrying me is this. Your lordships are right, it can be done.
Let's see further. Let's proceed.
Bear in mind, if it can
further.
be done in Jammu and Kashmir, why can't it be done in Gujarat? Why can't it be done in Maharashtra? Straight at page.
Okay.
So, Lord,
Let's see
that's
further.
something
Let's
which you
proceed.
have to bear in mind.
Let's
It can't
proceed further.
Now, Lord, please turn to para 44,
Are you on point?
straight at page.
Are you on point?
Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purposes of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean to Parliament that the law necessary to make a law relatable to agreement has to be passed under Article 368 of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that the law necessary to implement the agreement has to be passed under Article 368. Then, my Lord, 368 is extracted, and then your lordships may kindly turn. On the other hand, 516, para 47. This is very important. Just see, my Lord, how your lordships were viewing, my Lord, democracy. On the other hand, this is very important. Just see, my Lord, how it has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present. It has to satisfy. That is to say, it should obtain concurrence of a substantial section of the house by a majority, which may normally mean the consent of the major parties of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house.
Now,
Meaning, you must carry everybody on board.
After
So
this,
now
we
look
have
at it this way.
Mr. Dwivedi will be
Not
arguing.
construe even
Or Mr.
majority, not
Right.
to be major
Between
parties
the
of
three
the
of
house.
you, if you
Meaning,
could please
must
request
carry
that
everybody on board.
after this we have
the time so that,
Mr.
by lunch
Dwivedi will be
tomorrow we have
arguing.
completed
Or
with
Mr.
Mr.
Dave, Mr. Dwivedi and Mr.
Say towards, but I'll
Between
finish
the
in one
three
and a
of
half
you,
hour.
if you could please request that could you apportion the time so that by lunch tomorrow we have completed with Mr. Dave, Mr. Dwivedi and Mr.
Say towards, but I'll finish in 1.5 hours.
So David, could we do this? Maybe if we give an hour to Mr. David, 10:30 to 11:30 tomorrow, then Mr. Nafade about half an hour. Would that be all right? So David, could we do this? Maybe if we give an hour to Mr. David, 10:30 to 11:30 tomorrow, then Mr. Nafade about half an hour. Would that be all right?
But some overlap is bound to be there.
Make it.
One of us have his own views. Faced with the situation, I will see that overlap is minimal. But some overlap is bound to be there.
What we were thinking was that by tomorrow, because tomorrow is Thursday we complete one side, so that then next week the other side can open. So What you were thinking was that by tomorrow, because tomorrow is Thursday, Friday is miscellaneous. Thursday we complete one side. So if you could, in the evening today, next just week, as you step out of the court, Mr. Dave, Mr. Nafade, Mr. Dwivedi, and Mr. Siu Singh. So if you could, in the evening today, just as you step out of the court,
But I
Mr.
am-
Dave,
I am also appearing in the
we fall
matter.
behind many of the arguments which have preceded him. And then Dr. Menaka.
I am appearing in the matter.
I don't know, Gopal,
I am also appearing in the
fall
matter.
behind many of the arguments which have preceded after we rise, and then between all of you, so that we wrap up
I am
by
appearing in the
tomorrow on
matter.
this side. The sixth of the Learned Council, if you could just meet for 5 minutes after we rise, between all of you, so that we wrap up by tomorrow on this side. Absolutely. Interveners may give us short one-page written submissions on both sides, so that interveners can give us one-page written note on both sides. So we will not hear interveners on this side and interveners on this side. Interveners may give us short one-page written submissions on both sides, so that interveners can give us one-page written note on both sides. So we will not hear interveners on this side and interveners on this side.
But then,
We'll have
we
written
have
notes of
just
arguments,
as
I
the
think.
petitioners challenge it. We also have an interest in seeing, my lord, that the
All right, we'll see tomorrow. But what we'll do is,
But then, my lord, we have
please
just
do
as
sit down
the
tomorrow
petitioners
between
challenge
yourselves.
it, we also have an interest in seeing, my lord, that
So, all right, we'll see tomorrow. But what we'll do is, please just do apportion time between yourselves, so that we are not, we don't really err in the side of giving someone more than. So, Mr. Parekh is also there. So, between yourselves, if you could just apportion time, so that we are not, we don't really. All right, we'll give you up to Tuesday. But tomorrow now, tomorrow, if you could please do this, that you can give us now exactly how we'll finish our wrap up with all right. We'll give you 5 minutes Tuesday, but tomorrow now, after we rise, it'll help. Tomorrow, if you could please do this, that you can give us now exactly how we'll finish our wrap up with by Tuesday. So just 5 minutes, if all of you sit down on this side after we rise, it'll help. Thank you. Certainly.
Deeply obliged.